I know we don't have 45 days because Parliament is about to close, but Parliament is closing in maybe about 3 weeks. So there was a concern, is one day going to be sufficient for this honorable committee to ingest what's going to be brought to its attention? And some of them even thought that maybe the committee is just ticking a box to say that we invited people, but then they came for just one day, that there was not sufficient time to make a presentation, and all the others. I raised this matter on the floor of Parliament, and I asked that sufficient time be availed for stakeholders to raise their views, to give their opinions, and the presiding officer indicated as such, and yourself, as chair, you also stood and said we are going to give adequate time. I don't know if one day is adequate time, but I have brought the concern to your attention. Let me now proceed to my presentation. Honorable chairpersons and members of the Joint Committee, I appear before you today to vehemently...
Can we respond to that first?
No
to
problem.
lay your fears.
No problem.
Honorable Lope, yesterday we met the move of the bill. We had planned to meet some stakeholders as well, but we couldn't make it. We are not here for only today. We have received over, we should be in the region of about 100 interests. And today we are just starting. Our usual procedure is to allocate every stakeholder time, but that is also problematic considering that sometimes issues of jam and all that. So we decided let all the stakeholders come here, we deal with them. We have the whole of Monday, we have the whole of Tuesday. If we have not covered ground, we have the whole week. If next week is not enough, we have the other week. If the other week is not enough, we have up to 11th. If 11th May is not enough, there is no worry. The bill will be withdrawn and probably introduced in the next Parliament. If we cover ground today and we are done, tomorrow we have a report. If next week is not enough, we go to the other week. So there is no worry. We have so many stakeholders. That's why you think we are too many, but next week is even going to be more loaded. Thank you.
Thank you for that, your response. There is an English adage that once bitten, twice shy. I was before you, Honorable Baka, when we were dealing with the UPDF amendment bill, the iPod bill, and a plethora of others, and also then time was promised that we were going to have adequate time, and the time was not availed. And you remember, I raised that same concern on the floor. I said, but the committee promised us there's going to be several days availed to stakeholders to air out their views. But that didn't happen. You remember, Honorable Baka. But it's good you have responded. We shall hold you to your word, Honorable Chairperson and Co-Chair. Let me go to my presentation now. Honorable Chairpersons and members of the Joint Committee, I appear before you today to vehemently oppose the Protection of Sovereignty Bill 2026 in its entirety. While cloaked in the language of patriotism, a careful legal analysis reveals that this bill suffers from fatal constitutional defects, including unjustifiable limitations on the fundamental rights, dangerous vagueness, and an unconstitutional subversion of the multi-party dispensation. In our current political climate, where the state keeps persecuting people and state persecution has forced opposition leaders and critics out of the country, this bill ceases to be a theoretical threat. It is an immediate existential danger to political pluralism, economic survival, and Uganda's standing in the global community. To appreciate the gravity of this bill, I invite the committee to examine the chilling day-to-day realities that this law will create across all sectors of Uganda if passed. 1, reclassifying Ugandan citizens as foreigners. The most insidious provision is hidden in Clause 1, which defines a foreigner to include B, a Ugandan citizen residing outside Uganda. There are numerous Ugandans who live in the diaspora, and they remit over $2.5 billion annually to our country. All these citizens are going to be deemed foreigners by this law. When did this government cease to care about its citizens to the extent of regarding them as non-citizens. Consider a political leader born in Uganda, a registered voter, and a duly elected party president who is forced into exile or out of the country due to state persecution. Under Clause 1B, the moment that citizen crosses the border to save their life, that law strips them of their Ugandan identity and reclassifies them as a foreigner. Because Clause 1 defines an agent of a foreigner as anyone who acts under the direction or control of a foreigner, and Clause 2.2a says the act applies to anyone who engages in political activities, for or in the interests of a foreigner. The domino effect is devastating, Honorable Chair and members. Imagine a party official in Kampala receives a WhatsApp voice note from this party president who is out of the country, instructing them to coordinate some party activities. Under this bill, by following those instructions, the party official here in Uganda is guilty of engaging in political activities for a foreigner who left the country. Under Clause 14, they face 10 years in prison. Under Clause 5.4, they face 20 years in prison. A local party administrator or aide, simply doing their job by taking instructions from their leader, becomes a felon. Let me talk about the direct assault on the Political Parties Act and the multi-party dispensation. Articles 71 and 72 of our country's constitution, the grand norm, guarantee the freedom to form political parties, operationalized by the Political Parties and Organizations Act. The bill violently contradicts this act. Millions of Ugandans live abroad. Suppose a Ugandan doctor working in London pays $100, roughly 380,000 Uganda shillings, into the bank account of his local political party in Kampala as membership dues. Because the doctor in London is considered a foreigner under Clause 1B, the local party treasurer has just received foreign funding. If this pushes the party's annual foreign funding to over 20,000 currency points without the minister's approval, the treasurer of that political party faces 20 years in prison under Clause 22, and the funds are forfeited to the state. This is not right. By placing a cap on foreign money, which includes diaspora remittances to parties, the Minister of Internal Affairs is handed an absolute veto over opposition party financing. If the minister dislikes an opposition party, he simply refuses the written approval for their diaspora funding. The party is financially suffocated by state fiat, directly violating our country's constitution. Let me talk about the unconstitutional overbreadth and vagueness of this law, this bill. The legislative drafting of the bill fails the constitutional test against vagueness, granting the executive arbitrary power to punish dissent. Is the catch-all foreigner. Clause 1E allows the minister to declare any person, institution, or body a foreigner. Suppose a local trade union stages a strike demanding higher wages, embarrassing the government. The minister can simply sign a statutory instrument declaring that trade union a foreigner. Overnight, the union leaders become unregistered agents of a foreigner and they face immediate arrest. How can this be right? Clause 2.2h states that the act applies to anyone who influences the public to oppose the policy of government. As the leader of the opposition, my literal duty and the team that I work with is to oppose government policy that is injurious to the citizenry and offer alternative policy positions, which we do every so often. A local civil society group running a radio talk show explaining why a new tax is harmful could be jailed for 20 years. That's problematic. I bring in one or two examples, the Russian and Chinese blueprint, importing authoritarian toolkits. This bill that we are discussing is a copy and paste of the most oppressive foreign laws adopted to liquidate any opposition to government. The Russian precedent. Russia's foreign agent law, which is mirrored in our Clause 21, was used to stigmatize NGOs and jail opposition figures like Vladimir Karamazov for 25 years for opposing government policy. Clause 5.4 imports Moscow's playbook to Kampala. There's also the Chinese precedent. Clause 3.2 designates a department responsible for peace and security, that is ISO, as the entity to register agents of foreigners. This mimics China's overseas NGO law, which placed the Ministry of State Security in charge of all NGOs. Handing ISO, in our case, this power means opposition politicians and NGO workers, many of whom I see in this room, will not face auditors. They will face intelligence operatives. Now, let me talk about decimating the NGO sector and humanitarian response. Clause 22 restricts foreign funding to 400 million Uganda shillings annually without ministerial approval. Clause 7.4 makes it a crime, which could fetch one 20 years in jail for an agent of a foreigner to develop a policy without cabinet approval. Consider a local NGO fighting HIV and AIDS. They rely on partnerships with the Global Fund or World Health Organization, which are defined as foreigners under Clause 1. If local doctors sit down with these partners to draft a new national HIV treatment policy and present it to the Ministry of Health without first getting cabinet approval, the local doctors will have committed an offense under Clause 7.4 and could face 20 years in jail. There's the global precedent of India and Ethiopia. India used one of its laws to cancel the licenses of 20,000 NGOs, including Amnesty International, causing a massive collapse in humanitarian aid. Ethiopia's similar law decimated its civil society before they were forced to repeal it. Uganda cannot afford to scare away every international health, education, and refugee support organization, because that's what this bill would be doing. Economic self-sabotage leading to mass unemployment, scaring off foreign investors, and hurting Uganda's brand. Beyond politics, Honorable Chair and members, this bill is an economic suicide note. It creates a hostile environment for capital and labor, directly worsening the severe economic pain already biting Ugandans. That's why I'm calling it an economic suicide note. Legislative cruelty in the face of the USAID crisis. Honorable members, we are currently reeling from the recent withdrawal of the USAID support, which has pushed thousands of Ugandan health workers, implementers, and NGO staff into immediate unemployment. Families are failing to pay school fees, mortgages are defaulting. In this exact moment of crisis, this bill proposes to classify every remaining foreign donor as a foreigner, capping their funding at just 20,000 currency points without a minister's stamp, and threaten local NGO staff with 20 years in prison. To pass this bill now is an act of legislative cruelty. It guarantees that the European Union, Gavi, the Global Fund, and private foundations will look at the 20-year jail terms for local staff and withdraw entirely to avoid legal liability. That's what will happen. The thousands already rendered jobless by USAID will have absolutely no hope of being reabsorbed into the sector. This bill will deepen the unemployment crisis exponentially. Criminalizing the private sector and foreign investors. A foreign mining company or manufacturing plant operating in Uganda is a foreigner under Clause 1D. Under Clauses 7 and 10, if that company's local Ugandan CEO or legal counsel advocates to a ministry for a specific regulatory framework, for example, tax breaks for manufacturing, they are deemed to be influencing the development of government policy on behalf of a foreigner. They face 20 years in prison. No serious foreign investor will bring capital to a country where legal advocacy for their business interests is criminalized as foreign interest and interference. Stigmatizing every Ugandan in formal employment. Clause 1 defines an agent of a foreigner as an employee or servant of a foreigner. This means every Ugandan working for MTN, Standard Chartered Bank, Toyota Uganda, the UN, or any foreign embassy is technically an agent of a foreigner. Under Clause 14, they must register with ISO. If their employer inadvertently runs afoul of these vague regulations, the Ugandan employee will go to prison for 10 years. To mitigate this massive legal liability, Foreign companies will simply stop hiring Ugandans in senior roles or pack up and leave entirely, destroying Uganda's brand abroad. We are currently, as a country, negotiating with the IMF for debt relief and positioning Uganda as an investment hub. If this bill passes, global headlines will read, Uganda passes Russian-style foreign agent law, jails citizens for talking to exiles. Investors do not read the fine print of our clauses. They look at the headlines and move their billions to Kenya, to Rwanda, or Tanzania, or elsewhere. This bill makes Uganda look like a rogue state, and it pains me to say that, jeopardizing our trade preferences under AGOA and the EU. Let me address gagging the media and paralyzing the financial sector. This bill weaponizes vague economic and security terms to paralyze banks and silence journalists. Clause 13 criminalizes economic sabotage, publishing information that weakens or damages the economic system. Suppose an investigative journalist publishes evidence that a senior government official stole $50 million from the National Treasury. International investors panic and the shilling drops. Under this bill, the government can arrest this journalist for economic sabotage and jail them for 20 years. The crime of this journalist becomes exposing the theft, not committing it. And yet we should be encouraging everybody who has capacity to expose corruption and to bring it to the fore such that it gets punished. After all, the IGG told us we lose 10 trillion shillings to corruption every year. That's money we should plow back into the economy. Weaponizing commercial banks. Clause 25 dictates that a bank cannot pay out money to an agent or foreigner without proof of ministerial approval. If a bank fails to do this, they face a civil penalty of 200,000 currency points. That's 4 billion shillings. No bank CEO will risk this. They will preemptively freeze the accounts of opposition figures, NGOs, and media houses out of fear. The state won't need court orders to freeze opposition accounts. The bank will do it for them, given this law. Let me end with legal redundancy. We seem to be trying to solve a non-existent problem. The memorandum of the bill falsely claims that there is no specific law upholding the sovereignty of the country. Legally, this legislation is entirely redundant. If a foreign embassy tries to fund a violent coup, for example, the Penal Code Act already criminalizes treason, which is punishable by death. If someone launders illicit foreign money, the Anti-Money Laundering Act already mandates declarations of source of funds. If foreign funding goes to government institutions, the Public Finance Management Act already strictly regulates that. If NGOs, many of whom are in this room, flout the law, the NGO Act already provides for a framework of sanctions. The only gap this bill fills is the loophole that currently prevents the state from classifying an exiled Ugandan opposition leader as a foreigner, to bypass the Political Parties Act and jail their local supporters. Conclusion and prayer. Honorable chairpersons and honorable colleagues, as you draft your report, I entreat you to visualize the kind of Uganda this bill creates. A Uganda where a citizen out of the country is stripped of their nationality. A Uganda where a party treasurer goes to Luzira for receiving membership dues from a Ugandan in Saudi Arabia. A Uganda where thousands of already unemployed US aid workers watch their remaining colleagues flee the country rather than face 20 years in jail. A Uganda where a foreign investor's local lawyer goes to prison for drafting a policy memo. A Uganda where international NGOs flee, taking our healthcare and refugee support with them. Passing this bill will not protect Uganda's sovereignty. It will kill the multi-party dispensation, plunge thousands more Ugandans into absolute poverty, chase away foreign investment, and turn our country into an international pariah. And I hasten to add, clearly this bill is intending to stifle dissent. This government, in my view, should be excited to receive criticism from political leaders, from civil society organizations, from members of the general public, because they are all stakeholders. When we say healthcare is grappling, when we say there is corruption, that should not be a bad thing that warrants a whole bill to try and stifle that dissent. Government should listen to those concerns of Ugandan people so that it can improve, so that the taxpayer money that is given to government is put to good use. Any serious government should have that at the back of their minds, as opposed to finding ways to shut people up. That's not right. In light of the foregoing, I respectfully pray that your joint committee recommends the total rejection of the Protection of Sovereignty Bill 2026 in its entirety. I beg to submit.
Well, here in Parliament, we have a way of clapping. We don't use hands. But, and that doesn't mean we haven't received and appreciated. I want to thank Leader of Opposition for this candid presentation. I'll give a chance to his team to introduce it, because these are people's representatives. It's important that they go on record that they attended the committee and they are part of this. Please introduce yourselves. I'll give, I think we should give Leader of Opposition 3 questions if they're there. Then we give him a chance to go and, but kindly introduce yourselves.
Thank you, Chair and members. My name is Muwada Nkunyenji, Member of Parliament for Chadondo County East. And the Leader of Opposition, I'm the Shadow Minister for Foreign Affairs.
You're most welcome.
Thank you, Chair and your team. I'm Susan Mugabe, the Woman Member of Parliament for Buvuma District. Under the leadership of the Leader of Opposition, I'm the Shadow Minister for Fisheries. Thank you very much.
Most welcome.
Thank you very much, Right Honorable Chair. My name is Nyakatwa Sinas. I'm the Woman Member of Parliament for Hoima Oil City and the Shadow Minister for Agriculture.
Welcome.
Thank you, Chair and Honorable colleagues. I'm Charles Tebandeke, MP Bale Constituency, Kayunga District. In line with our law, the Protection of Sovereignty Bill is not only ambiguous, vague, but against the spirit of Ubuntu, should be set aside.
Thank you, and you're welcome.
Dear Chair and your members, I'm Kaya Christine Nachimwero. I'm Chiboga District Woman Member of Parliament, but the Minister for Water and Environment in the alternative government.
Wonderful. So, honorable colleagues and our visitors, this is the beauty about our Parliament. So the Leader of Opposition and his cabinet appeared before the committee and made their presentation and prayer. And we can assure you, we are going to scrutinize and make sure their ideas are considered. Honorable colleagues, those who joined us can introduce themselves. And maybe to clarify this presentation does not stop the Leader of Opposition and the team for making more amendments even on the floor of Parliament. No, it does not. It gives them even further chance. Any question to Lop and the team? Honorable Taylor.
Thank you, Honorable Chair. And thank you, the Right Honorable Leader of Opposition, for your insightful submission on the bill. Yesterday, when we received the move of the bill, that's the Minister for Internal Affairs and the Attorney General, there seemed to be a consensus on conceding to certain parts of the bill, and he threw it back to us, as it is indeed our responsibility to sanitize or cleanse where spots of dirt are envisaged. From your submission, and in conclusion, you invite this committee to reject the law in entirety. And one of the highlights you make is the definition of a foreigner, which the move of the bill also seemed to suggest that it's upon this committee to review where we find it inappropriate. So in line with that, in case an option for total rejection of the bill is not one of the options available to the committee, and because we need to come up with a good law, I invite you to look at clause 2 on the application of the bill, where it applies to any person who acts as an agent of a foreigner, and then subclause 2, for the avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means. This seems to suggest that it's not a blanket application. And the activities are there listed. Right Honourable, are you open to having a discussion on how to improve some of these provisions, or you still stand by only one position, that the law in entirety should be rejected? And should you have another option to improve some of these provisions, what is your take on the application of the bill, specifically on clause 2, subclause 2? Thank you.
Thank you, Honourable Taylor. One more. Honourable Okeo.
Thank you, Chair. I also want to thank the Right Honourable Leader of Opposition for the presentation. I wanted the Right Honourable Lope to look at Political Organizations Act. What does it state about foreign funding? And if it is very clear that it doesn't include subscription fee, what would be your take? Because actually the bill is brought to us either to throw it out, do enough surgery, and you know the process the bill takes before it is eventually enacted into law. We do a lot of surgery and refining. How would it be? Then secondly, ISO. You say ISO, is it housed in Internal Affairs or in the President's office? Because in your report you are clearly stating that it gives the mandate to ISO. And in the bill, this is a committee or a body that will be housed in the Ministry of Internal Affairs. I wanted you to really elaborate ISO in Internal Affairs or ISO in Presidency. Thank you.
Thank you. Thank you, Honourable Keo. I think that's fine. We can, let's give a chance from Honourable Wakoli, who came a little delayed. Introduce yourselves, please. These are Ugandans. They need to know you are here.
Thank you, Chair. And
yeah, up to Honourable Werike, I think.
My name is Wakoli Godfrey, and I represent the people of Tiru County, Manafa District, and member of Defense and Internal Affairs Committee.
Most welcome.
Thank you, Chair. Thank you, Chair. I'm Achai Juliet Lodo, Member of Parliament for Ngora County, a member of the Legal and Parliamentary Committee.
Most welcome.
Good morning, Chair. Good morning, our guests. I'm Arni Torau Ben, representing the people of Sinjiro West in the Sinjiro District and a member of the Defense and Internal Affairs Committee.
Welcome.
Thank you, Honourable Chair. Good morning, our guests. Good morning, members. My name is Adeke Anebaju, Soroti District Woman Representative, also a member of the Shadow Cabinet. You're welcome, our Leader of Opposition.
Most welcome.
Christopher, Member of Parliament of Olo West Manava District and a member of Legal and Parliamentary Affairs Committee.
Good. Honorable Alex.
Thank you, Chair. My name is Alex Nyonsaba. I'm the Member of Parliament for Bufumbira South Kisoro District and a member of Defense and the Internal Affairs Committee.
Thank you. Yes.
Chair Oseku Richard Oriebo, Kibale County in Palisa District.
Great.
But just a minute, Chair.
You have a comment?
Yes.
Okay.
Yes.
So those are three.
Yeah, they make the three you had earlier on said we
okay,
give the
please.
leader of opposition. Yes. Thank you for the presentation. In your, I think, point 9, you allude to legal redundancy of the bill. But immediately under, you seem to acknowledge that there are already laws that exist that the bill again is trying to address. However, on the side of the movers of the bill, they indicate that there is no single law, meaning that these provisions that are in here attempt to consolidate, to bring all the other laws into one single law in order to address the issue of sovereignty. Do you find the bill still redundant, or is it simply a case of bringing all the other laws together and perhaps by way of having a single law other than going back to amend all the other laws in order to be able to address the objective of the bill? Thank you.
Thank you, Honorable Riebo, Honorable Kahonda. Then we give a chance to the Right Honorable Singh.
Thank you, Chair. Good morning, everyone. Captain Kahonda, retired, is my name. I'm a member of Parliament representing Ruhinda South, Mtoma District.
Okay.
And I'm a member of Defense and Internal Affairs Committee.
Thank you. Honorable Odul, I thought you were this side because UPC is going to... Okay, but you're most welcome, Honorable Odul.
Thank you, Chair. My name is Jonathan Odur. I represent Erute County South constituency in Mira District. I am the Shadow Minister for Justice and Constitutional Affairs.
So you are part of this presentation?
I am, but I am seated here as a member of
Absolutely.
the Committee of Legal and Parliamentary Affairs.
In your own right.
Yes, and
yes,
I
you're
came
welcome.
late because I was covering for the leader of the opposition
In the House, yeah.
this morning.
Okay. Okay, honorable colleagues, I think we give a chance to leader of opposition to respond. Then we give him a chance to go and attend to urgent matters in the plenary. To you, Honorable Senyonyi.
Thank you, Honorable Chair and the Co-Chair and colleagues on the committee. And for the questions that have come through, I'll begin with the one of Honorable Kai. Political Parties and Organizations Act regulates activities of political parties. And so everything about political parties is encapsulated therein. Your question about ISO is Internal Security Organization. And in their modus operandi, they work alongside the Ministry of Internal Affairs. So that's the nexus there is. Honorable Taylor mentioned that the movers of the bill, Internal Affairs and the Attorney General, seem to concede on a number of provisions. So I think what you're saying is, would it be okay maybe to alter some of those as opposed to total rejection? I think I'll tie that in with the last question about my remarks referring to this bill as legal redundance. As I mentioned earlier on, we have a plethora of laws that capture the critical concerns that government would have, whether it be anyone flouting any law in as far as the relationship between Uganda and any other country is concerned, somebody out of the country and so on. I mentioned them, Anti-Money Laundering Act. The Penal Code Act captures a number of those provisions. And that's why I'm saying that this particular bill is irrelevant. The good lawyers, the majority of the members of the committee are lawyers, including the leadership of the committee. It is not helpful when you keep putting together pieces of legislation over things that are already taken care of. Again, you cannot have an act of parliament for anything and everything. Each act of parliament will encapsulate numerous issues. But the assertion that for anything and everything we must have an act of parliament, that means parliament would be sitting every single day to pass like 50 bills every day, which is not helpful. So my insistence is that we already have adequate laws that cover anyone that would bring in money into Uganda illegally, anyone that would trade outside of the law, anyone that violates any law in this country. None of us is above the law. Just because you're a member of parliament does not mean you cannot commit an offense and be taken on by the law. Should we now have a bill entitled an act of parliament legislating how a member of parliament gets arrested and arraigned in courts of law? Because a member of parliament is a citizen of Uganda. The Penal Code Act captures how any citizen who is assumed to have committed an offense gets to be arrested, taken to courts of law. Whether you're an ordinary citizen, whether you are a military person, whether you are an honorable member of parliament, and so on and so forth. So we cannot have a bill now for, this one is for members of parliament, this one is for councillors, this one is for ministers, this one is, you get the point I'm making. So that's really my general feeling. So it's redundant to that effect. That even when we alter and say, as the Attorney General is saying, okay, we can change the meaning of a foreigner so that Ugandans in the diaspora are not considered foreigners. So didn't these people prepare in their legislative drafting? Why did they not foresee that? That is very problematic. And that's why we are saying this bill is irrelevant, because the intention is not really the law. That's why now they are quickly conceding and saying, okay, let's adjust this, let's adjust the other. Clearly showing it is not relevant. We already have got a plethora of laws that provide for any breakage of any law by a Ugandan here or a Ugandan in the diaspora. The other day, Dr. Kizza Besigye was abducted from Kenya and brought here. They said he had committed an offense in as far as Uganda is concerned. Fair enough. Of course, what we have been saying is, can he have due process? Which has not yet happened. But he was picked up from Kenya. Is there any law? Yeah, they are referring to a number of laws already in place. Penal Code Act and so on and so forth, Anti-Terrorism Act, and all of the others. What we are saying, of course, is let due process happen, try the man, instead of being fungible all over the place. So I don't think, honorable colleagues, that we need to enact a law for literally everything. So in finality, again, I would like to entreat this committee. Let's not be seen to strip the people of Uganda of their sovereignty. The Constitution provides for the sovereignty of the people of Uganda. That sovereignty is not given by the executive. It is not given by this parliament where we sit, honorable colleagues. No. It is inherent and captured resultantly in our country's constitution. So that sovereignty is in place already. But we seem to want to take away that sovereignty, because sovereignty includes that as a Ugandan, I'm a stakeholder, I must be concerned about the happenings in my country. If I'm a taxpayer and I see my tax money is being stolen, I should have the right to voice out a concern and say Minister X, MP X is stealing my money. That should be my right as a citizen. But we seem to want to strip that away from them. Don't criticize. But why? They are stakeholders too. Why doesn't government want to be criticized? There should be no problem with that. But also saying that as a citizen, you are not supposed to critique government policy. Why? Because you see, we seem to now want to put it on paper that this government is authoritarian. That's what it appears to be, Honorable Chair. Because we are saying when government comes up with a policy, all of us must just oblige and follow. No citizen is supposed to critique it. But surely, what happened to participatory leadership? the people of Nyabushuzi should have a say in whichever government policy you come up with, because they are stakeholders, they are taxpayers, you are their voice, and that goes, of course, for the people of Nakar West and whichever. We are their voice, but they should be able to participate. So when we sit in Parliament and come up with a law or a policy, they have the right to go on a radio station or to call into any program and say, I disagree with this government policy. But what this law is saying, when you criticize government policy, we are going to arrest you.
Which particular clause law?
Honorable Chair, I have made my presentation, except if you want me to go back to it.
No.
I'm making my summary.
That criminalizes...
that if you are pushing through a policy, courtesy of a foreigner, against government policy, that's what you seem to be saying. So if a Ugandan says, I disagree with this particular policy, then you say, no, you seem to be influenced by foreigners to oppose this government policy. Let's give the people of Uganda a free rein to critique, to share their views, to give their input.
Thank you.
It's good for leadership. I thank you.
Thank you. Okay, let the co-chair say something.
I just wanted to say something before the law takes leave. And just to amplify, I didn't hear the concerns of Honorable Taylor. Maybe I missed, but I didn't hear you respond to specific issues that he put to you. Now, the Attorney General was here and clarified to us and said we must pay attention to Clause 2, because Clause 2 in the bill is the scope of the bill. Because once you miss, according to him, once you miss Clause 2, then you'll meander a lot. You'll meander a lot with a thinking that this bill, for example, is targeting everyone in the manner that has been discussed by some people. So according to the Attorney General, what he told us, this bill excludes, for example, NGOs in charity, in churches, excludes churches, investment companies, banks, multilateral organizations, family remittances, private remittances, law firms, business ventures. All those, according to the Attorney General, are out of the purview of this bill. So, Clause 2, Honorable Taylor was engaging your indulgence on whether, in the event that entirely rejecting the bill is not one of the options in the committee, how do you help the committee for us to be able to deal with Clause 2? Because Clause 2 also can be trimmed further for clarity. I'll give an example. You have just talked about government policy. Shouldn't citizens oppose government policy? Yes, citizens can oppose government policy. But if you oppose government policy for the interests of a foreigner, we cannot allow that. Why? Uganda decides, for example, to say we are going to do irrigation using the waters of the Nile. And you know some countries have interest in the waters of the Nile. Uganda wouldn't, for example, want Uganda to utilize that water such that it can be able to flow to the Mediterranean. So, a country downstream, for example, funds against such a policy of widespread irrigation. So, these people who are opposing that government policy, because they have been funded by a country downstream, for example, would be promoting interests of a foreigner. So they are within the ambit of Clause 2. But ordinary opposition of, organic opposition of Ugandans going about their work and opposing government policy or laws, that one is not within Clause 2. So I think myself, that whereas government seems to be interested in talking of adverse foreign policy, it is vulgarized. For example, the definition of foreign policy, foreign interest, is not so clear. So it is vulgarized. It could easily spill into even foreign policy which is friendly to Uganda. For example, an international NGO that is funding charity work, helping school fees to PWD children, vulnerable children. That one is friendly. Foreign interest, but friendly. The other one was subversive. it's not so clear in the bill, and I think we need to help the move of the bill, if that is his interest, because that seems to be the interest, that subversive foreign interest is what they are talking about, not just foreign interest, and it was not clear. So we need to be helped, that in the event that the option of throwing out the bill entirely is not there, how do we trim clause 2 to ensure that there is precision and clarity on what exactly we are talking about?
The Honorable Baka Stephen Mugabi, chairperson of the Legal and Parliamentary Affairs Committee, has made an interesting statement. He has said that if you want to influence government policy in the interest of a foreigner, we cannot allow that. Those were his remarks. Those remarks have worried me because he's a co-chair of this committee. He seems to have taken a decision already, and so our presence here is irrelevant.
As a Ugandan.
That's very worrying.
Not as chair, but
no,
as
but
a
you see,
Ugandan.
as a chair, with due respect, you're supposed to be a neutral arbiter, because now you're intimidating all these people who have come to make presentations, because they want to make a presentation in opposition to the statement you have said. But now the judge is already passing judgment and saying, we cannot allow that. I want to request that we remain neutral, so that these people can share their views. Otherwise, when you pass judgment already, we can very well pack up our bags and go away, because you're just ticking a box. Also because, Honorable Baka, you see, clause 2A, 22A, says engaging in the political activities in Uganda for or in the interest of a foreigner. And then clause 1B, a Ugandan citizen residing outside of Uganda is a foreigner. But those Ugandan citizens, they remit $2.5 billion per year to their country. They come back home every so often. They've got business interests. They've got children they're paying school fees for. So if government passes an education policy, why don't you want them to oppose it? Because they're interested stakeholders. Their children are going to school here in Uganda. And so we should be concerned and capture all of these issues. Finally, again, Honorable Baka has said, in the event that throwing the bill out is not an option, why isn't it an option? Why are you ruling it out, Honorable Chair? Because this committee is clothed with all of those powers. Committees have thrown out business of government several times. In fact, even today on the order paper, there are some which are meant to be withdrawn. So there is room for that. Kindly don't create an impression that this bill is a do or die. It has got to pass. You have got the authority. Just to remind you, you're a senior lawyer, you know, as a committee of parliament, this bill is really at the whims and fancies of this committee. This committee can choose to say, government, we don't agree with this bill, we have thrown it out. Except if you want to say you are on gunpoint. I don't believe you are. I don't believe you are. So please don't make a statement to say that in the event that throwing the bill out is not an option. Let's give our views, and then the committee members will decide. What if they vote overwhelmingly to say, let's throw it out?
Honorable, I think you,
so,
with due respect, you meant to misconstrue Honorable Baka's statement.
Yeah, that's why
the reason for our being here
is
that we are open to receiving all the views. Please? Yeah. Okay.
Most obliged. So I just, because as a colleague we can share, to say, these people here who don't know how to operate, they might think now it is finito.
Right, Honorable Lop.
It is
you know how we do our prayers in court. In the alternative, was you pray, these election petitions are in court now.
And
they are saying,
and without prejudice,
declare me as the elected winner, but in the alternative.
Yeah, but you see, as a petitioner in court, you can choose to say, for me, this is my only prayer. And then court decides. So court should not say, no, you cannot have just one prayer, but I'm the one coming to court, so I can choose to have just one prayer. I thank you, Honorable Chairs and colleagues.
Let me make a comment.
Thank you. I think we applaud the leader of opposition and his cabinet. I shall request the Honorable Jonathan Odul, Member of Parliament, Elute, and now under my command to escort our visitor. And Lop, please, you are allowed to use this exit. It's only you and your team. Please use this exit behind the chair. Feel free. Odul is conflicted. Okay, Fox Odoy. Thank you. Thank you so much. Please. Okay, we will give a chance to UPC Lango? Oh, interesting. Or Honorable Rachel Magora, you are here also. Okay. Lango sub-region. Let us make this very clear, okay? We are, the teams that are led by honorable members of parliament, we are giving them a chance so they can join the plenary. We are doing but that shows you how this parliament actually respects this bill. You can imagine today is appropriation, but we are given a chance to run a parallel. So I hope, honorable colleague, you will stick to the clauses that we must. Okay, thank you. Okay, we are going to, and you can introduce the team. Please, over to you.
Thank you, thank you very much, Chair. Good morning, and members of the both committees. My name is Eunice Otukwapio. I'm a member of Parliament. I represent the people of Oyam County North. But today I lead a delegation of Lango people, a cross-section of people from Lango, who entrusted me a few days ago with a declaration to be read before you, Honorable Chair, and the co-chair, and your members. I'm here as well as a potential foreigner, Honorable Chair, and as a potential agent of a foreigner, because I am a researcher with links to foreign publishers and with links to universities as well. And I'm also a member of a family that is quite extensive, with members living abroad. So I'm a potential foreigner and an agent of a foreigner as well. Honorable Chair and co-chair, allow me quickly underscore 3 statements that serve, or that will serve as a context, or the context to the declaration of rejection of this sovereignty bill by the Lango people. A cross-section of people living in the Lango, including myself, Honorable Chair, are highlighting a potential constitutional tension between the bill's combined provisions, and especially Articles 9 to 15 on citizenship. The combined provisions of the bill clashing with Articles 9 to 15 on citizenship, particularly where statutory classification will affect the practical enjoyment of these rights and freedoms, Honorable Chair. And that is, or those are articles on citizenship which are protected. They are entrenched and can only be triggered by a referendum as per Article 255 of the Constitution. I thought I could say that clearly, and these are the 3 statements that underscore the very brief declaration of the Lango people. 1, that citizenship is a constitutionally protected status governed by Articles 9 to 15 as amended, and that these provisions establish the framework for citizenship and safeguard against arbitrary or indirect deprivation of that status. That where legislation produces effects that materially alter how citizenship is recognized or how citizenship-linked rights are exercised, it raises constitutional questions as to whether such legislation is indirectly undermining protected constitutional rights. 2, Honorable Chair, that it is a settled constitutional principle that Parliament cannot achieve indirectly through statutory definition or executive discretion what it cannot achieve directly without following the constitutional amendment procedure. That where a statute produces the practical effect of altering or restricting citizenship rights or their enjoyment, it may properly be subject to scrutiny as a potential disguised or indirect amendment of constitutional provisions. And finally, to underscore the context, Honorable Chair, that the combined effect of the bills, especially Clause 1, when read alongside the said articles of the Constitution, that is 9 to 15, will significantly alter the practical enjoyment of the constitutional provision on citizenship and political rights. Accordingly, Honorable Chair and members, these provisions require substantial revision to ensure clear definitions, appropriate safeguards, and careful constitutional scrutiny to ensure compliance with articles, especially 9 to 15 of the Constitution, and to avoid any indirect or de facto modification of protected citizenship and political participation rights. These statements, Honorable Chair, are stipulated on the document with the clerk. I now turn to the declaration, which is very brief, of the Lango people, and I'm happy to note that I'm accompanied by a cross-section of them. Some of them are seated behind, but quickly we have, introduce yourself.
Some of them are also this side.
Some of them are that side.
Yes.
Thank you so much, Chair. My name is Decan Grace Patricia, and I'm a representative of the business community.
Thank you very much, Chair. My name is Daniel Okello from Lira City. I serve as an Executive Director of Passionate Foundation Africa, and also I serve within...
Welcome to 11th Parliament.
Thank you.
Okay.
We are here to put record right on this bill, which the people of Lao generally are looking at it as an insult.
Noted, yeah.
Very serious insult to the loyalty and the patience.
Thank you.
Thank you.
Next.
Thank you very much, Chair and Co-Chair and honorable members and we the visitors. I am Nelson Adeakar, formerly 2016 to 2021 the district chair of Uyam, and currently re-elected as still the district chair of Uyam.
You must
I tried parliament, I'm still on the way.
They keep postponing your victory.
I think
Don't mind. Now you came, so...
So I'm here in the team to represent the political leadership from Laos sub-region to reject the bill.
You're most welcome. You're most welcome. Okay. Next.
Thank you, Mr. Chairman and members of this committee. Patrick Abal is my name. I come from the cultural realm. I'm a minister in the cabinet of His Highness Wonyashi of Lango.
We like the diversity of the team. Now, the declaration, please. Thank you. You're most welcome. Oh, no, that is UPC Lango. Okay, now the declaration.
My name is Kelo Vanessa Olwen. I'm a student as well as a social media user, and I'm from the Lao sub-region.
Okay, welcome.
Thank you very much, Chair, and your members. The declaration, which was passed on to me, Honorable Chair, on Monday, April 20th, 2026, in Lira City, northern Uganda. We, the people of the Lango sub-region, representing cultural leaders, religious leaders, civil society, academia, ICT innovators, content creators, farming communities, the business community, youth, students, and families, supported by the diaspora, express our unified rejection of the Protection of Sovereignty Bill 2026. While the stated objective of the bill is to guard against foreign interference, its provisions raise serious concerns about their impact on the economy, civil liberties, and the socio-economic fabric of northern Uganda and the country at large. Honorable Chair, the diaspora remains central to Lango's recovery and resilience. Clause 1 of the bill raises serious constitutional concerns by reclassifying Ugandans residing abroad as foreigners, potentially conflicting with Articles 9 to 15 and 17H of the Constitution. The bill further appears to seek, in effect, to amend or circumvent Articles 9 and 15 of the 1995 Constitution, as I earlier explained, an entrenched provision, honorable members. Any such amendment requires strict adherence to to constitutional procedures, including a national referendum. The approximately 2.5 billion shillings Ugandans send home annually sustains households, education, healthcare, and local investment. By introducing restrictive state controls, approval requirements, and potential criminal penalties on cross-border financial support, the bill risks severely disrupting these remittances, which are the lifeblood of many families. These inflows support construction, agriculture, and small businesses that employ large numbers of young people. Restricting them would have immediate and significant negative effects on local economies, particularly in Lango. Honorable Chair, members, religious and cultural institutions play a central role in community welfare. The bill raises several concerns. By reclassifying institutions that are supported by international partners of diaspora contributions as foreign agents. Clause 28 permits warrantless inspections of premises, which may include places of worship and private residences of religious leaders. They are unhappy with this provision. And then about financial exposure, there's high institutional penalties which could severely constrain faith-based schools and health facilities that provide a substantial portion of essential services. Honorable Chair, members, on the impact to the economy, creative economy, the Lango people are saying that the artists and creatives increasingly depend on global platforms and collaboration. The bill may expose individuals earning from international platforms or partnerships to classification as foreign agents alongside severe penalties, and that this creates uncertainty that may discourage innovation, limit income opportunities, and push creative talent out of the formal economy. Honorable Chair, the fiscal and economic implications. The bill introduces compliance requirements such as ministerial approvals for financial flows that may discourage foreign direct investment and private sector growth. A reduced tax base may in turn increase pressure on domestic taxpayers. Already they are suspicious given what transpired this week with taxes, with broader implications for economic instability or stability. They are calling for action, Honorable Chair and your members, that government considers withdrawing the Protection of Sovereignty Bill 2026 to allow for broader consultation and alignment with existing legal frameworks, and to the committees here and Parliament to carefully assess the constitutional, economic, and social implications of this bill and ensure that any legislation protects, not undermines, the livelihoods and rights of citizens. They conclude by stating, Honorable Chair, that the Protection of Sovereignty Bill 2026 raises serious constitutional, economic, and governance concerns. In particular, its provisions may affect entrenched constitutional rights, including citizenship, and therefore require careful scrutiny in line with constitutional procedures. We affirm that any changes affecting entrenched provisions, especially Article 9 to 15, must follow the prescribed constitutional process, including a referendum. The people of Lango, Honorable Chair and members, call for a legislative approach that safeguards sovereignty while fully respecting constitutional rights, democratic principles, and the socio-economic well-being of all Ugandans, for God and my country. Thank you.
Thank you, Dr. Pio, on your own behalf and then on behalf of the Lango people. Loud and clear. We thank you for your vigilance, the people of Lango, to have come forward and appeared before this committee. Thank you. And for the gentleman, not a bar, whose victory has been postponed, tell them today you are in Parliament. And that while there you performed well, so they should see how. But we thank you. We thank you so much. Honorable colleagues, is there... Yes, Honorable Fox.
Honorable Chair,
before we let Dr. Bal and the team take leave.
Honorable Chair, we have...
Dr. Pio, not Bal, yes.
We have a full house.
Yes.
We have well over 10 stakeholders.
Absolutely. More than that, actually.
we need to save as much time as possible and listen to them.
Yes.
Can I propose humbly that we suspend asking questions?
Okay.
We
receive
the stakeholders, and we can convene as a committee much later
Yes.
to discuss the wonderful proposals from the stakeholders.
I am persuaded by because why I'm doing that, before you come in, Honorable Dul, all the stakeholders who came here want to be listened to. And we are here to listen to you. So for cross-examination that can come late, because we should retain your contacts. If we have questions to ask, we'll send and we'll receive written submissions to that effect. Okay? So, Honorable Dul.
Thank you, Chair. I want to oppose Honorable Fox's proposal.
Because you are from Mulango?
No.
Oh, okay.
No. I'm proud, of course, to be from
Absolutely,
Mulango.
yes.
And I want them to know that my legislative experience is that there are open traps that can be set by the Committee for the Public and Ugandans to fall into. One such is what he has proposed, and we are not here to sanitize. Parliament is not running anywhere. The way Fox has communicated, as if we have a tight deadline to meet. If Chair, you confirm that.
No,
then
no, no,
don't
no.
waste.
No, we, in our opening remarks, we said we are here to listen to every Ugandan.
Yes, yes.
Both here and even those who are abroad.
I am experienced. I've been here. We have done with UPDF, I know. That's why I'm saying we are not going to hurry with them. We should cross-examine them because we need to defend the report on the floor. Even if I raise a minority, I need to defend it. Even when I'm from Lango, for example, I have a question I want to ask. So
No.
how do you then, as a member of the committee,
Let's give a chance to somebody who hasn't. Okay.
Thank you, Honorable Chair. Honorable Chair, there are some areas that even this witness can help us to do justice to this bill. Because actually dismissing them that we hold on until the end, and then eventually, if we are not given enough explanations, we call them back, is unfair. Let us not hurry. Let's listen
Honorable
to them.
Santa,
Let us interrogate
let me hear from you.
and get the information.
Thank you, Chair. Chair, when normally witnesses present like this, there are sometimes issues for clarification. And if we dismiss them, where else shall we get these issues for clarification, which will in turn help us to defend our position on the floor of Parliament, Chair?
Okay. Okay. I am now going to allow 2 questions to Dr. Apio and the team.
Again, Chair, that is unfair.
Well, you ask, because if I'm convinced, I can allow us 10, isn't it?
Yeah.
So let me give you the first shot.
Yes, all the members of the committee with questions can
No. What if the Honorable Dole just represent yourself and put your question?
Yes.
Thank you.
So the first question I have is that in this presentation, it is representing the people of Lango, and you have listed 11 categories, which I would not like to, in paragraph 1, under your introduction. But when it comes to owning the document, I see you are owning it as Dr. Eunice Otuko Apio, MP Oyam, County North, Uganda. I do not see the cultural leader clearly in this document. I do not see the religious leader clearly in this document. I do not see the civil society clearly in this document. I do not see the academia clearly in this document. And content creators, farmers, community, and etc. So, would you address us? Because with sovereignty, my understanding is about us Ugandans. We don't want to reach on the floor and then someone rises up and said, I am also from Lango.
And I wasn't represented.
And I was not part of it. So how do we consider this document representative of the people of Lango, either by the different heads, maybe one cultural leader should have signed, one civil society, or even the minutes of the meetings that you held, the attendance list would be important. If you don't have, then I would suggest that when you go back, you actually support. Because the movers of this bill are purporting that they are doing it for and on behalf of Ugandans. That's what they are saying. So we want to see as many Ugandans who are either for it or against, so that in the end we know it is you, the minister, and the Attorney General, who are imposing this bill on Ugandans, or Ugandans are actually opposed to it. So that is the concern that I have and I wanted to register.
Honorable Jonathan Odul, as a legislator and lawyer, the movers are not purporting. The Constitution gives them a mandate to propose law, and it also, the same Constitution gives mandate to people's representatives to scrutinize it. What we are doing.
I choose my words carefully.
Yeah, but if the words offend,
if you intend me to argue with you, Mr. Chair,
no, that's not that's not the issue. But thank you for raising that. For a group to say we, the people of Lango, I hear you loud and clear. We have a list of attendees who drafted the document, has been given to the clerk. But even then, that does not take away his concerns. We hope you will respond. Because these are less than 20, we don't know whether you retain, yeah. But, okay, second.
Thank you very much, Honorable Chair. Dr. Eunice, on your delegation, I think I had a young lady introduce herself. Did she say she's a student? Content creator, perfect.
Yes, I'm a student.
I really would like to hear a youthful perspective from the hugest users of social media and content creation. I want to hear your perspective on what the sovereignty bill does to you, just uniquely to you as a young person and a content creator. I'm very interested in you.
Thank you. That's Honorable Anna Adeke. Thank you. Honorable Sanja.
Sorry, mine is just small, and in addition to what the Honorable Odu stated, the member in her submission stated that she was presented to the committee a declaration from the various stakeholders. And the law that relates to documents and the authenticity of documents would require that such a declaration signatures be appended to it. I want to hear from the stakeholders, rather from the member, whether or not there are such appended signatures to the declaration, such that the committee in future looks at it. Thank you.
Thank you. Okay, this is great. So we give a chance to Dr. Pio to respond. Thank you. Dr. Pio.
Thank you very much, Honorable Chair and your members. As a people's representative, Honorable Chair, I take my time and I do my homework really well. I try to do that. I'm going to submit or resubmit again. That's twice, submit and resubmit this, which has actually
signatures appended.
Signatures is the original that was received by your office, by the office of the clerk, with the signatures as well. The additional signatures that I'm going to add to
lay
as well.
on the table.
So I think I request through you, Honorable Chair and Co-Chair, and you
clerk can receive
to lay this officially for your onward use. I think basically that is it. That's it from me.
No, Chair, before Dr. Eunice leaves.
Yes.
I have received this document and I've paid attention. I was kind of suggesting that you need to do some more homework. This document, which has signatures, it's titled Consultation Meeting on the Protection. A meeting took place. But out of that meeting, there was a declaration now. Not everyone who attends a consultative meeting agrees with the declaration.
Yes.
So those declarations must now have their own ownership on its own. So that is not challenged. Because, you know, we are facing, this is not a simple bill. We have a huge monster on the other side, also studying, that we need to deal with. So my opinion would be, when you retreat and go back, part of this declaration must be owned by signatures appended to the declaration and not to the consultative meeting. Because that's what I have here, unless I have a different copy.
No, yeah. I agree with this.
I don't know if
it was signed separately. I concede.
Thank you.
It was meant to go with the declaration, but because the pages are quite limited, it went over, it spilled over, the names spilled over, and the signatures spilled over to the next pages.
And have a clear heading that these are signatories supporting the declaration.
The declaration.
And then you submit.
Most obliged. Most obliged.
Thank you, everyone. So a question was posed on how the sovereignty bill affects me as a student. I'll put in, for example...
And the content creator.
Yes. So apparently, me as a student, I have a goal, or maybe in my mind, entirely, when I'm done with my bachelor's, I would want to apply for a master's, maybe abroad. So I would intend to apply for a scholarship. So, for instance, let me apply for, apparently right now, at school, I get upkeep from my relatives who are abroad, and in some circumstances, I'm expecting tuition as well. So, days reach whereby exams are approaching. I clearly need the tuition. The bureaucratic procedure, which is clearly listed in the bill, makes it very hard for me to get the tuition. Why? Because at the end of the day, I have to first give in my reason, and I have to get declaration before I can withdraw these funds. And also, if at all I'm to get the scholarship and I go to do my master's in another country, I lose my citizenship.
No, you don't.
Because it states that it defines me as a foreigner. It clearly defines me as a foreigner in the sovereignty bill.
No.
Then also, on for some circumstances, if at all I plan to work abroad to study, I lose full participation in Ugandan affairs, and as well, my connection to Uganda becomes legally a bit weaker, and also the Constitution clearly states that power belongs to us, the people. But the bill makes us the citizens to clearly seek permission before we act on anything. And it gives final authority to the government officials, which shifts the sovereignty from the people to the government entirely.
You have, young lady, you have addressed 11th Parliament. Congratulations. And that is what people's participation, isn't it? Thank you, Anna, for giving her this platform. Dr. Pio, conclude.
Thank you very much, Honorable Chair and your co-chair, and of course the members on the two committees. The people of Lango are requesting for a referendum. They are convinced that combined, the clauses of the bill combined and interacting with Articles 9 to 15 of the Constitution lead to a tension that is unsustainable.
Is that part of the declaration?
Yes, that is the context. And that is
part of the referendum on what?
On the question of the day, whether you reclassify or recalibrate who the Ugandans living abroad are or not on sovereignty as well.
Okay.
So basically that is it. That's what the people of Lango are saying.
Thank you.
Thank you very much for your
You
time.
did. Thank you. And the people of Oyam, they have returned you, isn't it? Congratulations.
Indeed. Thank you.
Thank you. Thank you. Okay, you can take leave, and you also you as a member of parliament, please, and your team. I'll ask.
Chair, with your permission, I would like to gift the student a copy of the bill.
Oh, wonderful. So please, the student has been given a copy of the bill.
With its contents, yeah. Please, please.
And ask her to read clause 2, its application. Close the, yeah, wonderful. Clap for her. She's the only one allowed to enjoy this. Okay. May I ask Honorable, oh yeah, so the team from Lango, you can respectfully take leave. Odul, you want to escort them? Honorable Dul, Jonathan, please.
Chair, I want to have my full attention to the matters in this house. So
Okay.
I'm not going to leave.
Honorable Werike would be best suited to escort them.
Honorable Elike, you've
of
been
his
mandated to escort the delegates from Lango.
Chair, I would ask that this team.
I am only giving you
yes, I'm
permission.
also giving direction because where they are passing.
No,
I'm going
that's
through
now your
a
responsibility.
lot of struggle. Let them go through the.
Honorable Apio, please, you're allowed to take this route. Yeah. Honorable Elike, please escort. But you know where your powers stop. Only at escorting. Okay. For those who are joining us for the very first time, I'm sure you appreciate how participatory this process is. Even those who have submitted written memoranda, we still give you a chance to make presentations. We have received a memorandum from Ugandans in the diaspora. They told me there are 17 fora. They have come together to form, they call it Uganda Global Forum. Their seat is being coordinated by about 5 people in Washington. We have their memorandum, and we are trying our best to see if technology allows us to see whether we can connect them on Zoom so that they participate in this. We are now going to give a chance to the Honorable Rachel Magora of Obangaina Fame to lead this, to be the next to make a presentation. Honorable Rachel Magora.
Thank you, Chairperson. We appreciate the privilege to be here as a team from the creative economy. My name is Rachel Magora. I'm a Member of Parliament and I serve as Chairperson of the Uganda Parliamentary Forum for the Creative Industries, UGAPA4C. I appear before you today on behalf of a coalition of 5 institutions that together represent Uganda's music sector, its film and audiovisual sector, and its literary works and publishing sector. These institutions
Honorable Rachel Magora, do you have a written statement? Because that seems to be very interesting. Honorable colleagues, Honorable Rachel Magora is leading the Creative Industry Coalition. Creative Industry Coalition. Okay. Go on.
Can I continue? Okay. I appear before you today on behalf of a coalition of 5 institutions that together represent Uganda's music sector, its film and audiovisual sector, and its literary works and publishing sector. Those institutions are the Uganda Performing Rights Society, UPRS, the Uganda Federation of Music Industry, UFMI, the Uganda Reproductive Rights Organization, URRO, the Uganda Musicians Association, UMA, and Uganda Parliamentary Forum for the Creative Industries. I would like to invite you to introduce yourselves.
My name is Martin Nkoyoyo. I am the board chairman at Uganda Performing Rights Society, UPRS.
My name's Kamlegea Suleiman Alpha, otherwise known as KS Alpha. KS Alpha.
KA Alpha.
I'm the director in charge of strategic planning at the Uganda Musicians Association.
Okay, welcome.
My name is Geoffrey Ekongot. I am the executive director at the Uganda Musicians Association.
Most welcome.
Thank you. My name is Matthew Nawiso. I am the vice chairman of the Uganda Federation of Film Industry.
Federation of Film Industry.
Yes, and also the president of the National Producers Guild of Uganda.
Most welcome.
Good morning, everyone. My name is Moise Chitwara, and I'm an artist, and I'm also the founder of Practical Stream. We are a global licensing platform, bridging the gap between Ugandan music creators and the global market. We've got offices in the United States and Europe, so I'm as guilty as they come. Thank you so much.
That's very interesting. It's a global coalition. You bridge the gap between creators and the market.
Music creators and the market. And as we all understand that, because mainly we are focusing on businesses, film studios, and video game developers. And we understand that most of the people who would pay the money that is worth of the Ugandan talent are outside Uganda.
That's perfect.
Yeah.
This bill affects you. Please, Honorable Rachel, can you switch off that microphone?
I'd like to make a personal comment on the social impact of the bill.
Yes.
When I came from Busoga to Kampala,
yes,
somebody said, Tetwalianga na banamawanga, because I'm a Busoga. I have never forgotten. I was just about 30 years ago. I have never forgotten, though I forgave. Now, the word foreigner is a social insult to Ugandan citizens. Whenever you're called a foreigner in your own country, you feel like you have been discriminated.
So I hope benge mnamawanga
in Kampala.
In Kampala. Okay.
So that means the word foreigner.
Honorable Chair, I'm very certain Honorable Dur, Honorable Santa are not able to understand, so I want to request Honorable Rachel to help.
Okay, in short, Omunamawanga is a foreigner. Because I was coming from Busoga, I was in Buganda.
Tetwalianga na mnamawanga.
Tetwalianga na mnamawanga.
Put, we never used to eat with foreigners.
To dine with foreigners.
Trust my Luganda.
I have never forgotten it.
Okay.
And when I saw the word foreigner in the bill,
you were, yes.
It reminded me, and I can imagine many citizens of Uganda who are abroad, our children, our cousins, will feel like they are foreigners if they are told they are foreigners. And this is the only country they know.
The Honorable Abudu Katuntu has just called me that word in Uganda.
And you know, I now can tell. So both of you, Jonathan Odul from Otuke, Katunt from Bugweri, so which now Gwanga. Rachel, please go on.
I will lodge the full written submission with the committee. This morning, I will make brief opening remarks and introduce the team that I have already done. We are not here to oppose the bill. Uganda has a legitimate interest in protecting institutions from foreign influence, and this parliament has the right to legislate on that matter. We support the objective. We are here because the bill's current drafting inadvertently captures Uganda's entire creative sector. 3 industries, 3 collecting management organizations, and an estimated 40,000 registered artists within its scope. Not by design, as collateral damage of definitions that are broader than the bill's stated purpose requires. The consequences are severe. Some of them are irreversible. None of them serve the bill's purpose, and they can be corrected with 3 targeted amendments that leave the bill's core anti-interference provisions completely intact. Chairperson, I'd like to introduce the team. I have already done that has appeared here. Geoffrey Ekongot, the Executive Director of the Uganda Musicians Association, will deliver the substantive submission covering the music sector, the film sector, and the literary works in turn. Thank you. Mr. Ekongot.
Thank you, Honorable Rachel Magola, and thank you, Honorable Chair. Our written submission covers all 3 sectors in full. This morning, I will take the committee through the core problems in turn: music, film, and literary works, and close with 3 amendments that resolve them. I'll take approximately 9 minutes. Every problem we are about to identify in music, film, and in literary works begins at the same place, the 2 definitions in Clause 1. Clause 1 defines an agent of a foreigner as any person whose activities are financed.
Page 1.
This is the oral submission. Clause 1 defines an agent of a foreigner as any person whose activities are financed, supervised, directed, controlled, or subsidized by a foreigner. Receiving payment from a foreign entity finances your activities. No intent is required. No political purpose is required. The commercial relationship alone is sufficient. Clause 1 also defines foreigner to include Ugandan citizens residing outside Uganda. That means a Ugandan musician living in London, a Ugandan filmmaker based in Toronto, a Ugandan author working in Nairobi. Each of them becomes a foreigner under this bill. Any Ugandan who collaborates with them or pays them triggers the agent definition. Clause 5, Part 3, then prohibits the agents of foreigners from engaging in activities that promote the interests of a foreigner. Again, Clause 5, Part 4, sets the maximum sentence at 20 years in imprisonment, and that is the foundation on which everything else we are about to describe is built. The first is the music sector. Uganda has approximately 40,000 registered musicians on foreign digital platforms. That includes Spotify, Apple Music, YouTube Music, Boomplay, Deezer, Audiomack, and many others. Every one of them receives income from a foreign company, which under Clause 1, every one of them is an agent of a foreigner. Under Clause 5.3, distributing your music through these platforms promotes their commercial interests, making it a prohibited activity. Under Clause 5.4, the maximum sentence is 20 years. The Clause 22 funding cap of 400 million means that a musician who earns more than that in streaming royalties in a calendar year faces criminal prosecution. A single viral track can breach this threshold, and there is no mechanism for artists to opt out of the definition. One such example is one of the artists who is with us here today, who in 2024 alone has had 14 million streams. And if you include the income from sync licensing, he could hit this threshold, just one person. Then there is UPRS. UPRS collects and distributes royalties through bilateral agreements with performing rights societies in over 100 countries. That is the mechanism through which Ugandan musicians receive income when their music is played on foreign radio, in foreign bars, on foreign streaming platforms. Under Clause 1, 5, 22, and 26 combined, UPRS cannot continue as a going concern. Its core function is distributing royalties to foreign rights holders. And this is prohibited under Clause 5.3. Its annual distributions will far exceed the clause cap in 2022. UPRS is a member of CISAC, the Global Performing Rights Network. CISAC membership requires distributing foreign royalties without restriction. This bill makes CISAC compliance impossible. If UPRS loses CISAC membership, all incoming royalties for Ugandan musicians from foreign broadcasts and performances cease. And I have to be direct, Caesar Crane settlement takes 5 to 7 years. That loss is not recoverable within this parliament. Then the second part is the film and audio-visual sector. The sector has the sharpest legal conflict in the entire bill. In March 2026, this bill passed the Copyright and Neighboring Rights Amendment Act. And the purpose of that act was to domesticate the multiple treaties, including the Beijing Treaty on Audiovisual Performances, whose purpose is to give Ugandan actors, directors, and audiovisual performers moral and economic rights over the use of their performances by foreign broadcasters and streaming platforms. UFMI is the instrument through which those rights are collected and distributed. The Sovereignty Bill, introduced in the same parliamentary term, makes collecting that income a criminal act, carrying a 20-year maximum sentence. Parliament cannot simultaneously confer rights under the Beijing Treaty through the 2025 Amendment Act and criminalize collecting the income in those rights through the Sovereignty Bill. These two statutes are irreconcilable, and that is not a matter of interpretation. It is a direct statutory collision that can only be resolved by amendment by one statute effectively nullifying the other. The film sector is also structurally dependent on international co-production finance. Feature film budgets routinely involve funding from foreign broadcasters, streaming platforms, and European film funds. Under Clause 22, a film budget of $150,000 in foreign co-production exceeds the cap by $43,000 before a single day of shooting. One of the members on our team here, who is a member of UFMI, him alone on one production, he had a budget of $5 billion. That was the last 2-3 years. And that alone would be a huge problem according to this bill. International film finance will exit Uganda and route through Nairobi and Lagos. Those relationships do not come back automatically when the law is amended later. Third is the literary works and publishing sector. Euro, which is the Uganda Reproduction Rights Organization, administers reproduction rights for Uganda's authors, publishers, journalists, and academics, photographers, and illustrators. It licenses photocopying, digital reproduction, and educational use of published works, and participates in international reciprocal arrangements through IFRRO, the Global Reproduction Rights Body. Euro faces the same structural problems as UPRS and UFMI. Under Clause 1, Euro is an agent of multiple foreign rights holders simultaneously. Under Clause 5.3, distributing reproduction royalties to foreign publishers promotes their interests. Under Clause 22, Euro's international distributions are capped. Euro cannot comply with both this bill and its IFRO membership obligations. Beyond Euro, every Ugandan author with a foreign publisher receives an advance from a foreign entity. That advance finances their writing. They are agents of a foreign accord under Clause 1. Every journalist paid by a foreign publication, every academic receiving royalties from an international publisher, every photographer licensed through Getty Images or Shutterstock, all of them automatically under Clause 1 become foreign agents. One specific legal point is Uganda is party to the Universal Copyright Convention. Article 3 of the UCC prohibits requiring formalities as a condition of copyright protection for literary works. Clause 14 of this bill imposes exactly that formality on authors collecting foreign royalties through Euro. That is an independent treaty violation that we have flagged in the written submission. There is a fourth problem, and that runs across all three sectors, and it is one that Parliament should find particularly uncomfortable. Clause 9.1b of this bill states that Uganda's foreign policy shall be based on one, I quote, respect for international law and treaty obligations. And that is not a preamble. It is a provision of the Act being enacted. It creates a binding statutory obligation. Clause 14 imposes registration as a condition of royalty collection, violating the Berne Convention and the Universal Copyright Convention. All these are treaties we just domesticated just a month ago. Clause 22 caps royalty income, failing all three steps of the WPPT's limitations test. Clause 5.3 to 4 criminalizes collecting Beijing Treaty income, cancelling a right Parliament created just a month ago. The bill requires treaty compliance in one clause and violates it in 3 others. Parliament should not pass legislation that contradicts itself on its face. Let me put a number on what we are describing. Conservative sector-by-sector modeling across film and literary works produces a direct annual loss to Uganda's creative economy of between 24 billion to 38 billion. That is higher than our earlier music-only estimates because it now includes the film and literary sectors properly. Kenya imposes no equivalent restriction. Tanzania imposes no equivalent restriction. Rwanda imposes no equivalent restriction. International co-producers, broadcasters, publishers, and grant-making bodies facing compliance risk in Uganda will route their East African investments to Nairobi, Kigali, and Dar es Salaam. Those relationships, once established elsewhere, do not return automatically. We are not asking Parliament to weaken this bill. We are asking Parliament to be precise about who it is targeting. And 3 amendments do that. First, amend Clause 1 to exclude persons receiving royalties, licensing income, or remuneration for creative work from the definition of agent of a foreigner. Delete the paragraph that reclassifies Ugandan citizens abroad as foreigners. This single amendment protects 40,000 musicians and the entire film industry and every Ugandan author with an international publisher. Second, amend Clause 5 and Clause 22. Add a new section to Clause 5 exempting creative work from the prohibition. Exclude creative income from the clause.
Just a minute. I think I'm now very attentive. Our clerks now should be very attentive on that matter. Because now these are substantive proposals.
Okay. Amend Clause 5 and Clause 22. Add a new subsection to Clause 5 exempting creative work from prohibitions. Exclude creative income from the Clause 22 cap. Reduce the Clause 5.4 maximum sentence for creative practitioners from 20 years to 5 years in a first offense. Third, insert one standalone CMO exemption clause. Nothing in this act applies to UPRS, UFMI, or Euro in the conduct of their royalty collection and distribution functions under the Copyright and Neighboring Rights Act. One sentence, it serves all three CMOs, and without it, the loss of CISAC membership for any of them is permanent and irreversible. Chairperson and honorable members, Uganda has spent 2 decades building the legal and institutional infrastructure that enables its musicians, filmmakers, and authors to participate in the global creative economy. The Copyright Act, the Beijing Treaty domestication, the CMO system, Parliament built these deliberately, and they are working. 3 amendments will protect them. 5 of our 7 recommended amendments are non-negotiable. The written submission provides the exact drafting language. Our coalition represented here today is available to work directly with the committee's legal drafters before the 3rd reading. The music sector, the film sector, and the literary works sector are not the target of this bill. We seek Parliament to ensure the bill's drafting reflects that fact. Thank you, Honorable Chair.
Thank you very much. You know, why we like your submission, you are putting forward proposals for amendment, although you want them not to. but they are amendments nevertheless. So we welcome it. So this helps us, honorable colleagues and visitors. When you are addressing us, point specific clause where you find a problem and give us a proposal. But when you say throw out, no, we are here to carry out surgery, to make sure we come out with something good. Is also part of the surgery?
Yes.
Haji Chiwanuka, can you introduce yourself?
Thank you, Chair. I'm Chiwanuka Abdallah,
Yes.
a member of the Defense and China Affairs Committee.
Yes, and being Friday.
I represent Mukono North.
Yes, and we, being a Friday, we take note and we give you, the chair can see you. Thank you. Oh, are you done? Creative arts? Huh? Wonderful. I think you deserve an applause. Honorable colleagues, I can see Jonathan Odul. Please.
Thank you,
You
Chair.
used to be a creative artist.
Thank you, Chair.
What happened?
Thank you, Chair. And I want to thank the Honorable Rachel Magoda for leading the team and the presentation of Mr. Geoffrey Ekongot. I have only one question for you. You tell us, we are not asking Parliament to weaken this bill. We are asking Parliament to be precise about who it is targeting. 3 amendments to do that. Supposing this bill is targeting the creatives, so do you still maintain your, actually the bill is targeting the creatives? Because in your presentation, as if it is targeting politicians, it's okay.
That's why he's saying they are non-negotiable.
Yeah, that's why I'm coming. So, should there be clarification to us, the committee, that the bill actually targets the creatives from the mover? That yes, we want to deal with these creatives. Would you still stand by this submission? That's all my question.
Thank you. Honorable Keo.
Thank you, Chair. I also want to thank the creative industry for this presentation. Just one question. You are suggesting that the term be reduced from 20 to 5. There is also the money part. How about the billions? Can you give your proposal if it is a billion being charged or imprisonment for 20 years? What would be your suggestion?
Okay. Honorable Taira.
Thank you, Chair. And thank you for the presentation. Do we have people in the creative industry who are engaging in political activities in the interest of foreigners?
We'll give you a chance to respond. Just switch off your microphone. Okay. Thank you, Honorable Taylor. Somebody whispered that the Honorable Justice, Abdu Katuntu is in the audience. Okay, Honorable Katuntu, if you are present, please introduce yourself.
Thank you, Chair. Thank you, Chair, for the introduction.
Okay. Okay, thank you, colleagues. So let's give a chance to Honorable Rachel Magola and the team to respond to those concerns.
If the clauses have been responded to correctly,
Yes.
I do not think it will be a target on any creative in this country. Because all we are requesting for is the economic rights and social rights that might be infringed by the bill. So I do not think if these are responded to in the way we wish, in the way we beg, in the way we pray, which will be a target against any of us. But that does not exclude Ugandans as a people, because sovereignty refers to the people. So let's look at the bill as Uganda for the people, by the people. I think that's what we should be looking at.
Okay. I think we, Honorable Katuntu, you have something to say? Or we can allow them to take leave.
Just one question. First of all, I would like to thank them for their elaborate presentation.
Yes.
They seem to have done some good research. And
yes, they did.
But on this note, when the bill should be clear on who it should target, can you advise us who should this bill target other than you?
Other than the creative art industry. Okay. Yes, I forget your name, but you wanted to say something.
I wanted to say something. Like we said, artists are not, or creatives are not criminals.
Not at all. And nobody's saying they are.
If any creative, commits criminal offense, they are dealt with like any other citizen, Ugandan citizens. And the funny thing, just like the leader of opposition mentioned earlier on, some of the things the bill is talking about are already catered for by other laws that are existing. So what are we saying? The way the bill is set, it's sabotaging the creative space that is just developing, that hasn't even started working. Just like it's been mentioned, and good enough, we have a detailed document, apart from the oral that he's been reading.
No,
we have another detailed document with the specifications.
Where is that?
It's
the one that's attached?
Yes, it's attached.
We have seen it.
That has detail.
Okay,
or even that recommendation can be detailed
close by close
to the detail. So what are we saying? We are not saying this bill should target certain people.
Not at all.
But as they bring it, we are in interest of government formalizing, working on its system for everything to be perfect. But in the same spirit, it should not break what exists.
Okay.
Yeah.
Good. I think this we are good to go. We can. We thank you so much. I'll ask my please because time. Okay.
And I just wanted to answer Honorable Tyra. He did ask that are there any creatives that are agents of foreigners? I want to say in the affirmative, yes. No. That is why we are here to say that the bill in its current text, in the affirmative, it is a yes.
Okay.
Yes. Because from where I stand, as a collecting society, UPRS, we work through reciprocal agreements where we sign with other collecting societies of other countries to collect on our behalf where our music is being played, Ugandan music is being played. And then
you also play theirs?
Yes, as we also play theirs. So they have to send us the money that they collect from their markets.
That's very interesting.
So, in the current text, in the affirmative, yes, we are agents of foreigners, and we are saying that is not a fair
We thank
ground.
you for having come forward. We thank you so much.
Do you engage in politics as agents of foreigners?
I think they have made their case, Honorable.
Okay.
They have made their case. Please, let's give a chance. Let us entertain Center for Constitutional Governance. Oh, UPC, you mean Uganda People's Congress? Are they here? They were the first, actually. Then after that, Uganda Center for Constitutional Governance. How many are you, Sarah? How small is your delegation?
Thank you, Chair. We are 7 people from the office, but escorted with the civil society organizations.
How many?
Well here. I think we are about 50 civil society organizations.
Okay, most welcome. So let's give a chance to Uganda People's Congress.
Thank you, Mr. Chairman. Thank you, Co-Chair.
Yes.
Thank you, honorable members, friends who have
I
come.
need to know whether, excuse me, the Uganda Bankers Association, are they here? You will follow the Center for Constitutional Governance. Okay, UPC.
Yes, friends who have been invited to present on behalf of the citizens of Uganda. Mr. Chairman, Co-Chair, permit me to say that the ideal situation of Uganda People's Congress is that the bill should be thrown out, but we've gone ahead to suggest, you'll see in the suggestion that we've given, in case it's not, to make it palatable for our citizens. So I'll ask my Chief Administrative Secretary to read the proposals that we propose as UPC. Thank you.
Thank you so much, my Secretary General, Honorable Bill Fred. My name is Mzai Faizo. I am the Chief Administrative Secretary of the party. This is the memorandum of the Uganda People's Congress on the impact of the Protection of Sovereignty Bill 2026. It touches the implications for political parties, civic actors, and constitutional governance in Uganda. I'll give it the context and the introduction. This memorandum has been prepared to express the views of the Uganda People's Congress on the Protection of Sovereignty Bill 2026, currently before the Committee on Defense and Internal Affairs and the Committee on Legal and Parliamentary Affairs. While the stated goal of safeguarding national sovereignty is legitimate, we contend that this bill is fundamentally unconstitutional and should be withdrawn without further consideration. The bill does not seek to address any genuine legal lacuna. Rather, it creates a redundant and overreaching regime that contradicts the 1995 Constitution of the Republic of Uganda. By attempting to regulate areas already covered by the NGO Act, the Anti-Money Laundering Act, and the Political Parties and Organizations Act, the bill offers no new protections. Instead, its excessive provisions pose a direct threat to the fundamental rights of citizens, the viability of businesses, and the delivery of essential services, because it seeks to resolve problems already addressed by existing law while simultaneously violating constitutional guarantees of citizenship and participation. The bill serves no valid legislative purpose and should be rejected in its entirety. Honorable Chair,
excuse me, some uncomfortable communication. You know, we have our visitors. We have plenary going on, and we are at a critical stage for appropriation. I've just got information from Speaker that there is a critical need for forum in the House. You can imagine how uncomforting that can be. So I have either I suspend this for up to afternoon, or half of us, a critical number, goes to the House and then we continue. How do you see that? Just a moment, just a moment. Honorable colleagues, I am not making orders, I am putting them. Yes. Yes. There are two options. Yes. Suspending this sitting so that we have quorum in the House to appropriate. We are on timelines, constitutional timelines, or big number can join plenary and we continue with these visitors.
Yeah, thank you, Chairman. I proceed?
Yes, Honorable Olanya.
Yeah, thank you, Chairman. My name is Gilbert Olanya. I belong to the Committee of Defense and Internal Affairs. Mr. Chairman, this engagement is very important, and it calls for all the members of the committee to be present. Aware that when these people are presenting, we shall sit, compile, and write the report. So it's very important for all of us to listen to them thoroughly. Therefore,
if the Speaker is calling us to be in the House, since the passing the budget may not take long, you may suspend for a few minutes. We go, we pass the budget, and we come back. But it's good for all of us to listen from these people.
Thank you, Honorable Dr. Lanya Odul.
Mr. Chairman, thank you. This has been a concern that we had raised
Yes.
with the leader of the opposition to the leadership of the House before I saw this situation. And the question we were asking, why the hurry?
No,
Why
there's no hurry. It's now.
Yes, that's what I'm saying. That's what I'm saying. We knew that Parliament would require. But why would you schedule a committee meeting when plenary is also on, yet you know that we have to represent our people both in plenary and also in this committee? It's an ethical dilemma that we were put in.
Okay.
Now, in the limited options you have given us to suspend or some members, I want to propose the third one, that you actually adjourn entirely if there is nothing that is pushing you strongly behind.
Honorable
We are
Anna
here-
Adeke, I hear you, Honorable Dul.
Even next week, because
Honorable Chair.
I also want to point out for members to know, passing a budget is not just a matter of sitting there. It's debate. And we are going to raise so many things. It's not just us to go and rubber stamp. We cannot say 15 minutes, we have passed and come back. We would not be doing justice.
I hear you.
So I propose we adjourn. I actually move a motion now.
Hey, no, before, let's listen to wow. Honorable Anna Adeke.
Honorable Chair, I really sympathize with you,
Yes.
as do I with also our guests.
Yes.
This sovereignty bill was introduced at a very wrong time during the session, and they want it to be passed in the shortest time possible. But amongst our guests, I see people that have traveled from far. I see people that have come from Teso. I saw people from Lango. There are people who were on the night bus at 3 a.m. to come here and make their views heard. Honorable Chair, I feel like you should communicate to the Speaker. She gave us this assignment, and we cannot process this bill without hearing the views of such people that have traveled that far. We are not assuring them that we are going to give them accommodation. They have to go back.
So what's your proposal?
My proposal is that we continue. If there is a lack of quorum in the House, it is not a making of this committee. It is them who gave us business at this cycle of the session. Let us proceed.
Excuse me, visitors. Here we don't do it that way. No. We don't do it that way. I know Honorable Deke has spoken on your behalf, but that's not how we conduct business. Honorable Taira, I'll come to you.
Thank you, Chair. First of all, I have to register my conflict of interest.
Yes.
Especially in the presence of the Bankers Association. I am a conflicted party. And on that note, I appreciate how busy and engaging that sector is.
Yes.
By them having time to come here.
Sure.
Then we ask them to go back and again come back. It is next to impossible. We must create means of having both activities take place and have them make their presentation before and they leave at once. Because we need their input in this bill since it directly affects them. So as the chair, we must devise a means of having this meeting to continue at the same time plenary ongoing.
Honorable Fox, I saw your hand up.
Honorable Chair, I think John, my wonderful neighbor here, has captured my concerns. We can run the two processes.
Yes, concurrent.
The members who elect to go and attend plenary can leave and go and attend plenary. Those of us who are not even appropriately dressed for plenary shall stay.
Honorable Zijan.
Thank you, Honorable Chair. For the record, Zijan David Livingstone,
Yes.
Legal and Parliamentary Affairs Committee. I want to associate with Honorable Wadeke. It would be a demonstration of lack of empathy on our part if we look at all these representatives of the citizens and not feel for the effort they have put into being here.
Okay.
It would also be a revelation of want of insight and foresight put into planning the meeting. If we ended up with a crisis of the House needing to proceed, as well as the committee and lacking the forum to do so. So I propose as well that we proceed and that we mind ourselves with what is happening here, and the presiding officer of Parliament will also know what to do in the situation she's in.
Okay. You know, we honorable colleagues, we are here as leaders. So let's put ourselves in that. Honorable
Chair.
Joel.
Honorable Chair, thank you very much.
Yes.
Honorable Chair, we are being guided by the head of the institution, and the head of the institution cannot tell a chairperson to do something and the chairperson denies it. So my suggestion is we can go to Parliament, to plenary, then at 2 we reconverge and have these meetings.
Okay. Let me make a ruling. I'll give a chance to UPC to continue presenting. I'll send an envoy to. Yes, let's please continue making presentation. We are going to see how we communicate, and then we come back to you on that. And we'll send our senior Honorable Abdu Katuntu to go and present to the presiding officer what we have here. Please, we send you, and we expect you to come and convey. We know you are a very technical and gumite negotiator. UPC.
Thank you so much, Honorable Chair and members. Key issues in the bill. 1. Labeling citizens as agents of foreigners. The bill's impact stems primarily from the extraordinarily broad definition of an agent of a foreigner. Under Clause 1, which is the interpretation, an agent of a foreigner is defined as any person who acts for, is employed by, or whose activities are directly or indirectly supervised, elected, controlled, financed, or subsidized by a foreigner. This provision is unconstitutional as it violates the right to a fair hearing.
In the meantime, please don't accuse us of being bad hosts. Tea is served at any moment in the extreme left corner. Pick a cup of tea and a bite. Please, this is your parliament. Please.
This provision is unconstitutional as it violates the right to a fair hearing and the presumption of innocence guaranteed under Article 28 of the Constitution of the Republic of Uganda. By using the word indirectly, the bill creates a chain with no defined end, potentially labeling a local nurse to a donor-funded clinic like the Aga Khan Hospital, or a journalist at Media House with foreign stakeholders like New Vision as a security risk. Foreign interests in New Vision include Nigeria's Industrial and General Insurance PLC, and US-based firms Pine Bridge Investments and AIG entities that also manage portions of the NSSF and Bank of Uganda Retirement Holdings. Label citizens as security risks based purely on employment or financial links without any evidence of wrongdoing is a form of guilty by association that contradicts the spirit of Article 1 of the Constitutional Republic of Uganda. Furthermore, the bill establishes a mandatory registration system under Part 3, requiring these agents to register with the department responsible for peace and security. Critically, the bill lacks a mechanism for the listing and registration. Once a person is registered, they remain an agent of foreigner indefinitely, creating permanent reputational damage and unfairly categorizing citizens as traitors. This creates a civil death that infringes upon Article 24, which protects citizens from inhuman and degrading treatment as it marks them with a permanent social stigma. Recommendation. This clause is inherently flawed and should be deleted. However, in the event that the House insists the law, we provide the following alternate recommendation. A person should only be declared an agent of foreigner if there is clear evidence that their actions cause actual insecurity. Such a declaration should not be an administrative fact but must require judicial involvement, ensuring the person is granted the right to be heard and that the state provides strict proof of a specific threat to national security. Furthermore, a clear legal mechanism for delisting and deregistration must be included to ensure that citizens are not perpetually branded as foreign agents once their relationship with a foreigner has ceased. Concern number 2, denial of citizenship for citizens living outside Uganda. Clause 1 of the bill defines a foreigner to include Ugandan citizens residing outside Uganda. This provision is patently unconstitutional. By classifying citizens as foreigners based purely on residence, the bill creates a legal fiction that attempts to bypass the entrenched protections of the 1995 Constitution of the Republic of Uganda. Specifically, 1, Article 9 of the Constitution guarantees that every person who was a citizen at the commencement of the Constitution remains a citizen. Article 14 of the Constitution and Section 17 of the Uganda Citizenship and Immigration Control Act stipulates that only citizenship acquired by registration can be lost, and even then, only on narrow, specific grounds. Under Ugandan law, citizenship by birth cannot be lost under any circumstances. The bill also conflicts with Article 12 of the International Covenant on Civil and Political Rights, which protects citizens from being arbitrarily deprived of the right to enter their own country. The bill fails to define a duration of residence for this foreign status or provide a path for reinstatement upon return. This appears designed to disenfranchise the diaspora and risks criminalizing remittances. Furthermore, Ugandan entities, including political parties and companies, cannot have their citizenship stripped simply due to their place of operation. This clause is a direct assault on the fundamental status of a Ugandan citizen. Recommendation, Honorable Chair. This clause is a nullity as it contradicts the supreme law and should be deleted in its entirety. However, in the event that the House insists on the law, we provide the following alternate recommendation. The definition of a foreigner must be strictly limited to persons who do not hold Ugandan citizenship. Citizens residing abroad must be explicitly exempted from this categorization to ensure compliance with Articles 9 and 14 of the Constitution of the Republic of Uganda, protecting their rights to vote, receive remittances, and return to their country without being subjected to foreign agent registration requirements. Concern 3, creation of a fundamental peace as an institution. Creation of a department for peace as an institution. Ideally, government departments are created through administrative systems rather than an act of parliament to ensure the legislature remains separate from the day-to-day executive functions. However, Clause 3 of the bill seeks to establish a Department of Peace and Security through legislation. This clause is unconstitutional as it violates the principle of separation of powers and Article 111 regarding the executive's authority to determine the structure of government departments. Furthermore, by failing to prescribe the department's composition, qualifications for leadership, or its specific reporting line, the bill creates a ghost entity with immense power but no accountability. This lack of transparency invites administrative abuse and violates the right to just and administrative treatment under Article 42 of the Constitution of Uganda. Recommendation. Parliament should reject the creation of this department as it is an executive function currently lacking any statutory safeguards. However, in the event that the House insists on the law, we provide the following alternate recommendation. Parliament must prescribe in detail the entity's composition, the specific professional qualifications required for its leadership, a dedicated funding mechanism, and a clear reporting framework to Parliament. This is essential to prevent the department from becoming an instrument of unchecked executive overreach and to ensure it operates within the bounds of transparency and the law. Concern 4 in the bill, Honourable Chair, the vague definition of the interests of foreigners and its impact on the economy. Clause 5.3 and 4 of the bill prohibits and penalizes the promotion of the interests of a foreigner. This provision is unconstitutional as it violates the principle of legality under Article 28(12) of the Constitution of the Republic of Uganda, which requires that every offence be clearly defined so that a citizen knows exactly conduct is prohibited. The bill fails to define which interests are illegal. This vagueness allows the state to criminalize legitimate economic activities, such as a Ugandan employee promoting a foreign company's products or citizens managing a relative's property. Such ambiguity chills the freedom of expression and freedom of association guaranteed under Article 29, as citizens will fear that any interaction with a non-citizen could result in a 20-year prison sentence. Recommendation. These clauses should be deleted for being void for vagueness. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill must be amended to provide an executive. I beg your pardon. The bill should be amended to provide an exhaustive and narrow definition of prohibited interests, specifically limited to acts that directly and demonstrably undermine national security. Furthermore, any determination of prohibited interests must be subjected to a judicial inquiry where the accused is guaranteed a fair hearing before any sanctions are applied. Concern number 5 in the bill, Honourable Chair. Prohibition of economic sabotage. The bill introduces a prohibition on economic sabotage without providing a legal definition for the term. This is unconstitutional and violates Article 28(12), as it creates a catch-all offence that can be used to suppress the right to demonstrate and the petition under Article 29. Under this clause, a legitimate consumer boycott or a journalist report on corporate corruption could be labelled as sabotage. This overreach also threatens Article 40, which protects the right of every Ugandan to carry out a lawful occupation, trade, or business. Since the Penal Code Act, Cap 120, already criminalizes the destruction of property and malicious injuries, this new provision serves only to intimidate those exercising their civil liberties. Recommendation, Honourable Chair. This offence should be deleted as it is both redundant and a threat to constitutional freedoms. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill must define economic sabotage strictly as the intentional and physical destruction of key national infrastructure. It must explicitly exempt the exercise of constitutional rights, such as peaceful demonstrations, academic research, media reporting, and consumer boycotts from the scope of this offence to prevent the criminalization of lawful civil expression. Concern 6 in the bill, prohibition of the exercise for which the government is responsible. Clause 6 of the bill prohibits any foreigner or agent for a foreigner from carrying out acts for which the government is responsible. This provision is unconstitutional as it violates the right to engage in civic activities and the freedom of association under Article 29 of the Constitution of the Republic of Uganda. By leveraging the broad definitions in Clause 1, this clause effectively criminalizes private citizens, NGOs, and the diaspora for filling critical service gaps. Historically, non-state actors have been vital during crises like the HIV/AIDS epidemic and the famous COVID-19. Restricting these services to a government-approved monopoly violates the state's duty under Directive 14 of the National Objectives and the elective principles of state policy, which mandates the state to fulfill the fundamental rights of Ugandans to social and economic justice. Recommendation: the provision of goods and services to the public should not be subject to such restrictive measures. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill must include an explicit public benefit exemption that allows any person or entity to provide essential services such as health, education, and disaster relief without prior ministerial approval, provided such acts do not involve the exercise of actual sovereign executive or judicial power. Number 7, prohibition of influencing the government. Clause 7 prohibits the development of alternative policies without cabinet approval. This is a direct assault on Article 38 of the Constitution of the Republic of Uganda, which guarantees the right of citizens to participate in the affairs of government. It further violates Article 29(1), subsection A, regarding freedom of speech and expression. In a multi-party democracy, the role of opposition and civil society is specifically to challenge and improve state policy. By criminalizing the creation of alternative policies, the bill effectively nullifies the Political Parties and Organizations Act and stifles academia and research institutions. Recommendation, Hello Chair, Clause 7 should be deleted as it is a hallmark of an undemocratic state. However, in the event that the House insists on the law, we provide the following alternate recommendation. The restriction should be narrowed to only prohibit the fraudulent personation of government officials or the issuance of forged official state documents. The right to research, propose, and advocate for alternative public policies must be explicitly protected as a core tenet of democratic participation. Number 8 on the prohibition on the implementation of government policy. Clause 8.3 bans the implementation of government policy by private actors and criminalizes the disruption of such implementation. This is unconstitutional as it violates the principle of legality under Article 28(12) because disruption is not defined. For example, a peaceful sit-down strike by UNATU, that's the Uganda National Teachers Union, over unpaid wages could be prosecuted as criminal disruption of the UPE policy. This infringes upon the right to strike and the right to peaceful assembly under Article 29. Recommendation: the vague restrictions in Clause 8 should be removed. However, in the event that the House insists on the law, we provide the following alternate recommendation. The term disruption must be strictly defined as the use of physical force or violence to prevent government officials from performing their lawful duty. Legitimate civic actions, including strikes, protests, and critical media commentary, must be expressly excluded from this definition. Disenfranchising Ugandans. Clause 11 prohibits Ugandans living abroad or those labeled as agents from participating in electoral processes. This is a flagrant violation of Article 59, which mandates that every citizen aged 18 or above has the right to vote, and Article 1, which vests sovereignty in the people. Disenfranchising millions of Ugandans because they live abroad or work for foreign-funded entities moves Uganda away from international best practices and constitutional requirements. Recommendation: Clause 11 should be deleted in its entirety. However, in the event that the House insists on the law, we provide the following alternative recommendation. The bill must be amended to ensure that no Ugandan citizen is deprived of their Article 59 right to vote or participate in a referendum based on their residence or employment status. Any restrictions should only apply to non-citizens attempting to interfere in domestic elections in line with existing electoral laws. Prohibition of economic sabotage. The bill's introduction of an undefined economic sabotage offense is unconstitutional as it violates the principle of legality under Article 28:12, which requires that every criminal offense be clearly defined. Without a precise definition, this provision serves as a vague catch-all that can be weaponized to suppress freedom of the press and freedom of expression under Article 29. For instance, a journalist at New Vision or an academic researcher could be prosecuted for publishing an accurate report on economic or security stability if that report leads to a drop in the company shares or investor confidence. Furthermore, by criminalizing actions like consumer boycotts, the bill infringes upon the right to demonstrate and petition under Article 29 and 38. Since the Penal Code Act, Cap 120, already addresses malicious injuries to property and economic crimes, this provision is redundant and serves only as an instrument of intimidation. Recommendation: the offense of economic sabotage should be deleted for being unconstitutional and redundant. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill must define economic sabotage strictly as the willful and physical destruction of key economic infrastructure. It must explicitly state that the exercise of constitutional rights, including investigative journalism, academic research, peaceful demonstrations, and consumer boycotts, does not constitute economic sabotage. Strict prohibition on foreign funding. Clause 22(1) requires prior ministerial approval for any foreign financial or material support exceeding 20,000 currency points, that's 400 million. This is unconstitutional as it places an arbitrary and disproportionate restriction on the freedom of association and the right to carry out a lawful trade or business under Article 40. By creating an administrative bottleneck with no defined approval timelines, the clause grants the minister unchecked power to decide which business or individuals can access foreign capital or grants. This redundancy is clear when considering that Section 14 of the Political Parties and Organizations Act already regulates foreign funding for political entities. Extending this to all individuals and business creates a hostile investment climate that undermines the state's duty to promote economic development. Recommendation: Clause 22 should be deleted in its entirety to avoid economic disruption. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill should be amended to replace prior clearance with a disclosure and reporting mechanism similar to the Anti-Money Laundering Act. Approval should only be required for entities already flagged by the Financial Intelligence Authority as being involved in illicit activities rather than imposing a blanket restriction on all legitimate foreign capital and grants. Extreme sanctions and punishment. The penalties under Clause 5(3) and 4, including 20 years imprisonment and fines up to 4 billion, are unconstitutional because they violate the right to protection against cruel, inhuman, or degrading punishment under Article 24 and the principle of proportionality inherent in Article 28. The lack of theoretical sentencing structure treats minor administrative oversights like a relative receiving a remittance with the same severity as acts of terrorism. Such draconian sentencing creates a regime of systematic injustice where punishment does not fit the crime. Recommendation: the punishment regime should be completely revised to match the gravity of specific, well-defined harms. However, in the event that the House insists on the law, we provide the following alternate recommendation. The bill must introduce a sentencing framework that distinguishes between minor administrative defaults, which should attract civil penalties or small fines, and serious criminal acts. Furthermore, maximum sentences like 20 years should be reserved exclusively for cases where state proves intent to cause physical harm or the actual overthrow of the constitutional order, or ensuring that punishments are proportionate and just. In conclusion, Honorable Chair and members, our considered view as Uganda People's Congress is that the protection of the Sovereignty Bill 2026 is unnecessary and should be withdrawn. The vast majority of its provisions are already addressed by the Political Parties and Organizations Act, the Anti-Money Laundering Act, the Non-Government Organizations Act, the Companies Act, the Anti-Terrorism Act, and the Public Finance Management Act, among others. Furthermore, many of its clauses are unconstitutional and effectively strip citizens of their sovereignty rather than protecting it. If there is a genuine need to enhance oversight of foreign funding, the government should instead strengthen the capacity of existing bodies like the Financial Intelligence Authority, the Electoral Commission, the Uganda Revenue Authority, which already have the legal mandate and expertise to regulate the flows. We so submit, Honorable Chair. Thank you.
Thank you, Mr. Chairman. Just 30 seconds, or within 1 minute. This bill, in summary, tries to erode the rights to the enjoyment of rights enshrined in the Constitution. And in this case, it reminds me, just like we are today, in a country where we are so politically divided and coming from fresh elections with economic activities disrupted, like the kiosks being removed from all over the cities and towns and people becoming unemployed. It reminds me of on Saturday, March 4th, 1865, Abraham Lincoln said to a country divided like ours. This is very critical for us to note because, as I told you, we need to have this in memory. I want to just put this last quotation and then you can discuss our submission. In a country divided like ours, Abraham Lincoln said this on Saturday, March 4th, 1865, giving his second inauguration address. He said, with malice towards none and charity for all, we should try to make laws which are not discriminatory, because it tries to divide between citizens of Uganda who are living abroad and citizens of Uganda who are here in Uganda. So we beg to submit this, and we're ready to take some few questions if time allows. Thank you.
Thank you, UPC. This document is very good. You can actually see the hand and the pen of Jonathan O'Doul.
No, Chair.
I don't know whether he's going to deny that he's a UPC MP or that he's good in drafting.
Chair, let me just put it on the record that this document demonstrates clearly the gap between UPC and the others. In fact, if UPC was in power, we would not be having this problem.
Now, you see, I told you, we legislate with the Honorable Jonathan O'Doul. The beauty with NRM is that we give credit where it is due. Yes, but thank you so much. This is good, to be sincere, because they point to a clause. They also make a proposal on how. So let's give a chance to honorable colleagues to ask some questions to you. I can see the hand of Honorable Anna Adeke.
Thank you, Honorable Chair. I agree with you. This is a really well put document. You can tell it's a legal researcher who put it together. So on page 6, under that item X, on the
strict prohibition
of foreign funding, you make a recommendation about amending to replace prior clearance with a disclosure and reporting mechanism similar to the Anti-Money Laundering Act. The financial systems, the financial flows of money in and out of the country, I presume, are already something that government has an eye into already as is. So what is new about this on this recommendation? Because I am well aware that government knows all the money that comes in, whether it's on phone or it's on a bank account, government is well aware of that. Secondly, the next recommendation that you give under the last point, you recommend that the bill should introduce a tiered sentencing framework, distinguishing cases that are more graver than the others, and you cite there something, reading verbatim, actual overthrow of the constitutional order. Actual overthrow of the constitutional order, if it fails, if it's not successful, is already punished, because there's an offense of treason that already exists. If a revolution is not successful, so the offense of treason already exists. Please speak to us how introducing this is not going to enable duplicity in criminalizing this same, because it's already exists and it's a provision that has been used over and over. There are many Ugandans who are charged and even facing currently court cases on the same. Thank you.
Thank you. Any other Honorable Nsanja of Nte?
Ntenjeru South, yes, right.
Nte Enjeru.
Ntenjeru, yes, White Cow. Mr. Chairman, thank you so much, and thanks to UPC. Mine is not a question per se, but actually, at the earliest, I wanted to. You did not catch my eye. I wanted to raise a procedural point. Because when you look at the very start, on page 1, in their introduction, they had insisted that this bill is fundamentally unconstitutional and needed to probably fundamentally be withdrawn without further consideration. And I was imagining why they were going further to present. And that is why, in their conclusion, they still repeat the same. But during their presentation, Mr. Chairman, they have been insisting in their recommendations. I thought the leadership, the committee leadership, would lay their fears, because they are insisting in all their recommendations, that in the event that the House insists, good, they are talking about the House, not the committee. So you need to lay their fears that this committee will not insist on something, especially when it is unacceptable by the public. Anything that is unacceptable by the public, this committee shall not go ahead and just forward it to the House, because it will be digested here, especially where there are fears from the public. That is what I wanted to communicate. Thank you.
Thank you, Honorable Sanja. Honorable Dr. Gilbert Olanya, then we give them a chance to, so that we can give others also time to make presentations.
Thank you, Mr. Chairman. Mr. Chairman, I would like to appreciate the UPC, led by the Secretary General and the team. Thank you. Mr. Chairman, the UPC team, their report and their ideas is quite factual and straight to the point. But I am wondering, from all your presentation, you are emphasizing on the deletion of all those clauses. But there came a time that you are changing your mind. I feel you should stick to the position. If you are saying the bill should be withdrawn, all the clauses should be deleted, just stick into that. Because having double mind is as if you are not trusting this committee, as if you are passing vote of no confidence on us.
No,
because you are saying, assuming you don't buy our ideas, do this. So what I'm saying is, Mr. Chairman, what I'm saying is, let them stick to their opinion. If you are saying the bill should be withdrawn, just stick into that, and the committee would decide to either discard the bill and we withdraw it. Otherwise, thank you so much for the good presentation.
We had the Honorable Anna Deke earlier made a remark that the bill was clearly drafted by a very strong legal mind, and in law we give alternatives. We don't stick to one position.
Yes, Honorable Keyo, then we give them a chance to respond.
A very quick one, Honorable Chair. I also want to commend colleagues from my father's party.
Oh, you see,
Thank
now you are
very much
declaring.
Honorable Chair, I wanted a quick one. They are clearly
People are starting to come out.
Honorable Chair, the document is stating that in case they are actually proposing that there should be a committee on peace and security. In case it is there, it is not defined. I wanted them to tell us if it is to be defined, it's to be headed by who, because we are under rationalization, marginalization, merger and whatever.
Rationalization.
I wanted to know, in case it is put in place, peace and security, headed by who, what qualification, because they say even the bill is not clear on qualifications.
Okay, thank you. And finally, feel free. This doesn't apply to only UPC, but all presenters. If you find a question that has been asked, you need technical input, or you need to go back and consult further, you are allowed to submit additional information later, the way you submitted your memorandum. Response?
I want to once again thank you, Chair and Co-Chair and honorable members for appreciating our viewpoint. We've insisted that this bill is bad for the country. That's our take, both in the preamble and the conclusion. But as you've seen, we provided alternate views in case you, as a committee, in your wisdom, insist to proceed with the bill, to take it to the House. That is our view that you take to the floor. So we are welcoming also because we trust that you people are well placed to know, to make it better. So where you find our resolution or our recommendation is not good enough, you can maybe improve it and take it to the House. But we have suggested that in our case, as a party, we think the bill is bad. It's already bad in a bad situation that we are in. So I would wish not to go into much details, but later on we shall provide more details to answer Honorable Adeke and then Honorable Balina, Honorable my good friend Okeyo.
Thank you.
Yes, thank you very much.
Okay.
Yeah, because of time.
Thank you. UPC, thank you so much. So, Constitutional Governance, Bankers Association, Human Rights Commission. Yes.
Thank you very much.
And please, you can, so that people. Honorable Odur.
Chair, before the next presenters come in,
So UPC now can take leave. Thank you. Okay, you want, please escort them. Thank you.
So, Chair, I wanted to notify
Honorable
you.
Dul.
I wanted to notify you that some of the stakeholders that want to appear before this committee have been blocked by Parliament.
Blocked?
Yes. At the gates, and they say they are no longer allowing. So I want to bring to your attention.
Okay.
So that you can handle it, because it's Parliament that invited them.
No, yeah.
And
Thank
if
you, thank you,
the same
Honorable John. Okay, let's assure you. I can clearly understand. You saw that from the start, the room was full. So I think, but now as more members exit, surely others can come in. Whoever has an idea will be free to give it to us. And this also goes to presenters, Honorable, Sarah Viret and the team. Because you have submitted, so you can actually highlight salient so that others also have a chance to submit. Over to you.
Yeah, thank you so much, Chair, and the Honorable Co-Chairs and Honorable Members of the Joint Committees on Legal and Parliamentary Affairs and the Defense and Internal Affairs. Together with me under the Center for Constitutional Governance, Sarah Birete is my name. I'm the Executive Director. I have Counsel Philip Kalgawa, our associate and a renowned advocate, as well as Counsel Simon Senyonga, also our associate, and a renowned associate and a faith leader. In the back, we have Miss Nancy, for the record, Caroline Ayot, and Miss Naiga Madrin, as well as Mr. Robert Biaranga. These are associates at the Center for Constitutional Governance. We shall break down our presentation.
You also said you are accompanied by about 50.
Yes, we are accompanied by representations from 14 regions in Uganda. And some of them
Let them stand up and we see them.
Yes, if people can come. And
okay.
Yes, and the Citizens Coalition Against the Protection of Sovereignty Bill that will be presenting a memorandum led by Job Keija. So, Chair, we shall specifically speak on constitutional issues.
Okay.
And leave the other actors.
Oh, so those are two presentations?
Yes.
If you
we shall be very brief.
Okay.
We want to concentrate on constitutional
Over to
issues.
you.
Thank you so much. So I want to invite Philip Kalgaba
Mr.
to
Chairman,
take us through.
Mr. Chairman, procedure. May you please help us with the copy of presentation? We don't have copies.
They actually did.
Yeah,
the
we
copy is
will let you
available,
follow.
yes.
And let the clerk.
The clerk will give it to you.
Yes, you direct the clerk to give
Okay, I direct the clerk to supply Honorable Dr. Gilbert Olanya with a copy.
Not
Go ahead.
only Dr. Gilbert Olanya, Chair, we do not have copies. Honorable Chair, it's not only Honorable Gilbert, we do not have copies.
Okay, all members of who were delayed by the plenary.
No, we were here before, Chair.
Okay.
To correct the record.
Sure.
Okay.
You deserve these copies. Okay.
Thank you so much. I think the clerk has been in touch with us for more copies, and our apologies on that. I want to invite Counsel Philip Kalgaba to quickly take us through the constitutional challenges with the proposed Protection of Sovereignty Bill. Thank you so much.
Thank you very much, honorable members, fellow citizens. I thought since the UPC members didn't use that phrase, I would use it for history's sake. Yes, so we thank the chairs for the assurance that everybody will be heard and that the bill will not be passed next week. Thank you. We are grateful to the delegations that have gone before for highlighting many of the issues with the bill, and we will not go in the same detail. We just will pick out salient points, starting with the whole concept of sovereignty, which the student from Lango, raised first on this floor. the whole concept of sovereignty and how this bill inverts a constitutional principle of sovereignty. And it vests in Article 1 of the Constitution, all power belongs to the people, who shall exercise their sovereignty in accordance with the Constitution. Power belongs to the people, and they shall exercise their sovereignty in accordance with the Constitution. Now, what the bill does, rather than protecting the people's sovereignty, the bill transfers the practical exercise of this sovereignty and places it in the hands of the Minister of Internal Affairs. It is the minister who determines who is a foreigner. By extension, who is an agent of a foreigner. It's the minister who determines which activities fall within the Act by statutory instrument. He also determines who may register and on what conditions. He also determines who may receive funding. The same minister may suspend or revoke registration at any time without prior notice. This is a single appointed official. He now becomes the gatekeeper of our civic participation, determining which citizens may engage in policy advocacy, receive funding, or operate organizations with any foreign connection. That's not protection of sovereignty. That is displacement of sovereignty. In Charles Onyango Bo, in clause 22G, the bill seeks to criminalize influencing the public to oppose the policy of government. What we are doing right now is to oppose the bill. That will be criminal when this bill passes. Okay. Charles Onyango Bo Constitutional Court said the free flow of information and ideas is essential to the democratic process by which people exercise their sovereignty. Clause 11 also purports to protect the electoral expression of the people's will under Article 1.3, but the definition of agent of a foreigner is so broad it would include domestic election observers, civic education organizations, and media outlets, all of which are essential to the free and fair elections that Article 1.4 of the Constitution requires. So the concentration of this discretionary power in the minister is fundamentally incompatible with Article 1, vesting sovereignty in the people of Uganda. The next point I just will touch on lightly is the vagueness and the rule of law. Vagueness around the definitions, around the prescription of offenses, and the rule of law. It just occurred to me this morning that if we maintain that a Ugandan resident abroad is a foreigner and cannot participate in politics, Uganda Law Society will be shut down. Isaac Chimaze Semakade has been in exile for 1 year plus. He's abroad. He's running Uganda Law Society. He would be deemed a foreigner. And Uganda Law Society would be deemed agents of foreigners and would require to register with the Minister of Internal Affairs. I'm not going to bet as to whether we would be registered. Yes. Now, even Ugandans resident abroad on official duty, our foreign service officers, would be foreigners. There is no exemption provided for them. Now, on this point, I would like to tackle the Attorney General's statement that we must focus first on Clause 2.2, and deal with that as we understand the bill. The Attorney General's argument is that the bill only tackles agents of foreigners who participate in activities under Clause 2.2. And there are many activities listed there under. Okay? But the definitions of foreigner, agent of foreigner, are in such broad terms that they capture literally every ordinary, commercial, professional, family, or charitable relationships that have no connection with foreign political interference or undermining of sovereignty. Now, we all need to be looking at the bill. I want to demonstrate that the bill uses the word agent of foreigner in a particular way. It also uses, when it's creating offenses, it also uses the expression a person. It also uses the expression or other person to demonstrate that the bill is not restricted only to agents of foreigners under Clause 2.2. And I would like to start with the biggest contention, Clause 21, requiring registration when you receive monies. It says an agent of a foreigner or any other person. And the drafting team can tell us, when you use the expressions parallel like that, okay? When you use the expressions parallel like that, you're referring to different things. You can't be referring to the same thing, okay? There's another provision. If you look at clause, when you use the expression in two expressions side by side, they refer to different things. They are not referring to the same thing. Like clause 21, which says an agent of a foreigner or any other person. The expression any other person is now dealing with somebody else apart from an agent of a foreigner. In clause 6.2, 6.4, 8.3, 8.4, the list is long. The expression there is a person or an agent of a foreigner. So this clearly shows that the bill's reach goes far outside agents of foreigners. Now, for the Attorney General, I would give him one word, one four-letter word, if he wanted to resolve this issue. He should have said, or the bill should have said, in clause 2.2, okay, that this law applies only to, and that's a four-letter word, only to foreign agents of foreigners who do the following. Or it applies to agents of foreigners who do only the following. Four letters, four-letter word, one. That would resolve that issue. And you'd also remove 2.1, which says it applies to agents of foreigners generally. Yes, we've suggested it. We've suggested it, yes. So I would like, and maybe I should not make too big a point of it, by going to show the categories of people who are, the categories of people who, as it stands today, would be affected by this bill by reason of the definition. A grandmother receiving remittances from her granddaughter in Saudi Arabia. Jaja is in Uganda, Muzukulu is in Saudi Arabia. Muzukulu is sending money for medicine. As defined agent of a foreigner, Jaja is a person who is being subsidized by a foreigner. As defined, Jaja is being subsidized by a foreigner. So Jaja has to go to the Minister of Internal Affairs and register.
Council Philip, have you applied your mind to clause 2?
That is what I started with.
Yes.
Yes,
So
that's what I
it doesn't-
started with. We can.
Would a judge come in?
Yes. 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 We can break down 2.2
Yes.
also, and I'll pick where the judge falls. Okay. Yes. So in 2.2, it says, okay.
For avoidance of doubt.
Yes, for the avoidance of doubt. And I
Yes.
might say that the regional expert on legislative drafting says, the minute, Dr. Okello in Kenya, the minute you say for the avoidance of doubt, yes, you introduce doubt. Okay, so it is not a recommended
drafting technique.
Okay.
Now, the challenge is the judge who is in Uganda, whose cost is being subsidized. Okay? And that subsidy comes from the definition of agent of a foreigner, the tail of that definition. So we are saying that the challenge to me is that she does not fall under 2.2.
It doesn't.
Okay. But I have demonstrated to you that she need not fall under 2.2 because 2.2 is not exhaustive. Okay? When we went to the penal provisions, for instance, when we went to 21 on requirement to declare, it says an agent of a foreigner or any other person. So the door is open.
Okay, go on.
Okay. In fact, the wording of the definitions is so wide. How do you say it in Luganda? You open the door, kupata. You've opened the door. Olugulide kupata. It can't close. Everybody can go through it. Thank you, Chair. So we've dealt with the grandmother.
Okay.
Let's deal with a fast food franchisee with a United States-based franchisor, and it could be any other country, a foreign franchisor. KFC here would be acting under the direction and control, and maybe partly financed also by a foreigner. So that person would be an agent of a foreigner and would have to register. A Ugandan lawyer serving a client abroad, and lawyer you can replace with any other professional. I'm not going to be selfish. Yes. Any other professional would also be an agent of a foreigner because they would be acting and representing foreign interests. Okay? They would be representing a foreigner before URA, UNBS, Uganda Registration Services Bureau, and so on. So all of us would be caught and would have to register. So I think that makes the point that Clause 2.2, which the Attorney General seeks to rely on, still needs to be further restricted if at all this is to go ahead. So continuing with other provisions that we would like to highlight, the freedom of expression under Article 29. The Constitutional Court just gave us a seminal judgment the other day called Alternative Digitalk versus Attorney General, in which they nullified the offense of criminal defamation and laid fundamental principles for freedom of expression. We now can't have provisions in a bill today that says it will be criminal if you express yourself, okay? Like economic sabotage. If you make a statement that damages the economy, then it's criminal. That's completely inconsistent with this recent judgment. The violation of the right to privacy, Article 27. Clause 15, Clause 16, the information which you have to submit to the Minister of Internal Affairs. The only thing missing there is the DNA. And I was scared to mention it because he might say, oh, we forgot, and include it. Yes, it's unfortunate. Now, let's compound it a little bit. In Clause 21, after a recipient of foreign monies has declared to the minister, after you've declared to the minister that I'm getting foreign money, and these are the reasons why I'm getting it, and this is who I'm getting it from, and so on, that declaration is a public document. Now, if it is a bank being financed by its foreign parent, why is that a public document? Why should that be a public document? Yes, why should it be a public document? If it is me being financed by, whoever is abroad, a friend, saying, I've given you money for what's the next holiday? Weekend, yes. Why should I declare what my relationship is with that person? The money is for me to go to Kalangala to enjoy myself. Why should that be public? That's a violation of the right to privacy. The right to equality and non-discrimination. The government has exempted itself. If the foreign funding
is from government, it is exempted. And worse than that, under clause 24.2, government can say, yes, I've got foreign funding, and I'm not going to put it under the Public Finance and Management Act. Then under what law will there be accountability? Under what law will government be accountable for these funds? It's the minister, two ministers, Minister of Internal Affairs and Minister of Foreign Affairs, can say, yes, we got foreign funding from China, but we are not going to funnel it through the Public Finance and Management Act. That's clause 24.2. Why would that power exist?
Are you saying the provisions of this bill,
yes, sir,
actually contravene the provision of Public Finance Management Act?
They empower the two ministers,
yes,
to disapply the Public Finance Management Act.
In particular, what clause? That
24.
Those are
24.
In 24.
Yes, you start with 24.1.
Okay.
And read it, then go to 24.2.
Okay.
I may proceed?
Go on, please.
Thank you. The disproportionality of penalties has been touched on, and we thank the delegations that went before us for raising that. The absence, and this chairperson is my last point, the absence of transitional provisions.
To this.
The bill requires a whole administrative structure to be put through to process 16,000 applications, presumably, that will come from recipients of money from the diaspora. Okay? It will require a whole infrastructure to receive applications to register as agents of foreigners. It will require a process of what the application form looks like, rules and regulations under the Act. It is not in place. But without transitional provisions, the bill will take effect on publication in the Uganda Gazette. Parliament passes it.
When the infrastructure for its implementation are not in place.
When the infrastructure is not in place. Overnight, all these agents of foreigners will be in default. Okay? For me as an individual, I can take the risk and say, catch me if you can. But for institutions, banks, yes, insurance companies, who must comply to local laws, it is an intolerable situation that they will be in default with such criminal penalties, $1 million, with their officials as well, automatically in default. It's a grave omission that's easy to remedy if at all the bill has to proceed.
Okay.
Honorable members, we urge you to reject the bill in totality for other reasons given in our paper. If there is need to regulate the foreign interference beyond the current legal framework, a new bill based on transparency and disclosure, modeled on the U.S. Foreign Agents Registration Act, would be more compatible with the exercise of people's sovereignty in Uganda and our Constitution. I thank you very much, chairpersons and honorable members.
Thank you. Council Philip Karugawa and the Center for Constitutional Governance.
Chair, with your indulgence.
Yes, Sarah.
Council Senyonga will submit very briefly on freedom of worship.
Should be very briefly.
Thank you very much, my colleagues and Honorable Chair, together with the members of Parliament. My name is Simon Senyonga, and I'm an associate with the Center for Constitutional Governance. And in the brief submission concerning how the sovereignty bill is going to affect the freedom of worship, we just want to make a case in about 3 or 4 points. Number one, it's a general observation that the religious freedom perspective, the bill introduces a regulatory framework that may extend into, number one, areas of worship, religious organization.
Particularly which clause? Because I thought those are...
Starting from clause 1, and I'm just going to break down very quickly.
Okay.
Starting with clause 1. But also, to put context to the conversation, reference was made by the Attorney General when he was submitting before this committee concerning the laws which they are picking inspiration from. Specifically, the FARA law of the USA, the Russian law. I think also other reference was made from Hungary. In the African context, we have Zimbabwe. I think also in the ministerial statement presented by Honorable Kahinda Otafire, there is reference to the Agaciro system of Rwanda. Now, for us to get proper context of this, it's important that in making the sovereignty bill, we assess whether the nations where we are making reference from have had a success story in regards to implementation of that law in relation to the freedom of worship. And that is mainly to aid the drafters of the law in terms of their research. Number two, at a broader level, we have talked about the inspiration of the law is to create fundamental limitations on various human rights. The question of Article 43 of the Constitution. And again, my submission is to the drafters to make, just to quote the case of Andrew Mwenda, Charles Onyango Bo versus Attorney General. The statement of the Supreme Court was that it is the fundamental human rights which are fundamental, not the limitation. And in that case, I would advise that we make, since Article 43 picks inspiration from the International Convention on Civil and Political Rights, you read it together with the Siracusa principles interpreting the limitations and derogations on the International Convention on Civil and Political Rights. There is a whole test that is to be passed that is applicable according to Article 43, and that will guide us in specificity when we are developing any limitations to that fundamental right. The other biggest concern, which I will not belabor, is how the law defines a foreigner. And this creates a risk in relation to how religious communities in Uganda are to operate, because there is a deep connection between religious communities and the diaspora. Now, the moment there is that kind of broad explanation of who a foreigner is, inadvertently it will get to affect the religious communities. And Honorable Chair, together with members of Parliament, I would like to aid again the drafters of this law that it is important. Many times there's an interpretation that the freedom of worship is only contextualized according to religious leaders. But I want to appeal to your conscience that each of us sitting in this room, according to the UBO statistics from the last population census of 2024, 85% of Ugandans are associated with a specific faith, Catholic, Anglican, Muslim.
That is not contested.
And what again I'm trying to drive to, Honorable Chairperson, it was to bring out the essence of the spirit of the law, beyond just the clauses. Because there is a danger in the drafting of the law for us to only look at the language of the clauses, but to inform, since we're here to have an engagement, the spirit of the law will aid us. But I just want to wrap up, Honorable Chair.
Please.
On something which is very important for the drafters of the law. I would advise that you look at how the USA, Zimbabwe, Hungary, Nicaragua, their foreign agents laws have made specific exemption concerning religious activities. And again, when you look at clause 2, which is in contestation here, there is a broad application without exemption. So in these nations which have been referred to, where we are picking inspiration.
Would you rather we exempt faith-based organizations?
Again, in a specific context of their legitimate operationalization of their activities, not in a broader sense, because as the people who have spoken before us have said, that the law should be applied equally across the board.
Correct.
And if a Ugandan, a religious leader, commits a crime, the penal code has even a specific whole provision concerning religious offenses. So it is important that in the creation of this law, there be clear exemption concerning and cross-reference to some of the laws we have talked about and how they are protected religious liberties, even as they're developing laws concerning foreign agents.
Thank you. Thank you. Thank you. Thank you very much. I think... Yeah.
Honorable Chair, can I please just conclude with this one point?
Conclude.
The question of clause 6, 7, and 8
But
about...
as you conclude,
Yes, please.
your two seniors have presented very well. You're also moving in the right direction.
Yes.
But you are pleading with us to help you reach the drafters so that you can facilitate the drafters to do a better job from your submission. And you have not really made very strong reference to this document which is on our record.
Very authoritative.
Which is a good document. So I'm now asking you, from what I understand, the Center for Constitutional Governance has directed our mind to several contraventions to the Constitution if we move.
Yes.
But for you, you seem to be saying it's okay, just do a good job and...
Let's give him a chance to conclude.
Is that how you are?
Please conclude, yeah.
Thank you very much. I think it's important that in the statement I am making, it is not to depart from what has been said.
Thank you.
I think it is just to give emphasis and detail concerning one of, because my colleague mentioned that we are looking at the contraventions of fundamental human rights. So we have picked one, which I'm speaking to, which is Article 29, the freedom of worship, religious liberties. So the clauses I'm making reference to speak to that fundamental freedom and the violations of the sovereignty bill and how it will affect those. But I mentioned that clause 6, 7, and 8 concerning prior approval of provision of services.
That was very well canvassed. Sure, very well canvassed.
Chair and honorable colleagues, I know that our document of Center for Constitutional Governance gives us extreme detail. We would like to appeal to you as people of faith and people who believe in consonance with the motto of Uganda.
You can see we have a Hajj here on Friday.
Yes, and just like how you have probably Christians and others, that it is important that as we determine and make this law, we make specific
you have made your point
to the protection of the freedom of worship and religious liberties. Thank you very much.
You have made your point. Thank you so much. Let's have, thank you, Center for Constitutional Governance. Philip Karugaba, you did us very well, no doubt. Most of these came after you, so they benefited a lot. Sarah, is there anything? Because I'm giving...
No. Thank you so much, Chair. There was a request from the coalition, the second memorandum. If you will guide, are they presenting after us?
No, but you see, you used your time for... Yes. Okay. And pick salient, whatever has been canvassed, you don't need to overemphasize. Yeah. Where you depart, where you have to emphasize, please do. Otherwise, yes. Thank you. Over to you.
Thank you.
I beg your indulgence, Chairman. We don't intend to break for lunch, so please, you get a snack so that we can be able to continue and rather than breaking.
But Chair, when I say snack become lunch?
Proceed.
Good afternoon, Honorable Chair, and good afternoon, Honorable Members. Honorable Chair, I would like to request
Come again?
My name is Patricia Munabi Babiha. I work with the Forum for Women in Democracy Forward. We have a slot on the agenda, so I am requesting that I make my presentation. It relates to what has been presented by CCG, so that we can cover the time slot that we had on the program within this time. Thank you very much.
Please do.
Again, my name is Patricia Munabi Babiha. I work with the Forum for Women in Democracy. I am here with a number of...
Is this now presentation for forward?
Yes.
Forward.
Forward.
Okay.
Forward.
Not forward.
No, Chair.
Patricia Munabi, the floor is yours.
Thank you very much, Chair. So I'm here on behalf of the women's movement, but also on the broader civil society sector, to present views that we have gathered since the bill came into the public. The views have been gathered from a wide section of the citizenry in their diversity. We have voices of grassroots communities, we have professionals, we have various interest groups across the country who have all been following the bill very closely. And our general consensus in our memorandum that we will present is that the bill should be withdrawn. We've been running a slogan that says, reject the sovereignty bill. And so we are here to ask the parliament...
Can we hear that again? You've been running slogans?
We are saying, reject the sovereignty bill.
Reject the sovereignty, okay.
Yes. So we are saying it should be withdrawn, and if need be, accorded more time for consultations across the country in a more transparent and open manner. Our memorandum highlights several critical concerns. Some of them have already been raised, so we will not repeat them. We will lay emphasis on the unconstitutional reclassification of Ugandan citizens. The definition of agent and agent of a foreigner are very critical to the whole of this bill. We will also look at the redundancies in view of the existing legal framework. We will also look at the various countries that have similar laws and how the proposed sovereignty bill is actually distinct in terms of how bad it is in relation to the other countries. So we thank you for giving us this opportunity, and we are hopeful that Parliament will listen to the people's will and actually reject this bill. I'll now ask my colleague, Job, to kind of take us through the key highlights of our memorandum, which we have presented and copies of which the members of Parliament have. Thank you.
Thank you so much, Honorable Chair. As Patricia has indicated, since this bill came into the public domain, we have been following it closely. We have followed the discussion online, and would like to make an offer, Honorable Chair, that you allow us to actually do the curation views that are coming through the online engagements, the media engagements, the public discussions, such that we can provide that report to you, and it can also help you to inform the decisions that you make as a committee. Because there's a lot of debate that is going on across the country, which I think this Parliament would actually benefit from to make a decision. And also, I really want to thank you as a committee for offering space actually to the public to discuss this bill, because I think this is the most widely discussed bill because it has serious implications for citizens and citizenship. Now, some of the calls that are coming through the discussions that are ongoing in the public is for this bill to be taken to the citizens and a referendum held on this bill because it has consequences for their citizenship. We have listened very meticulously to the justification that government is giving for this bill. And one of the things that they keep talking about is the fact that other countries like USA, UK, Australia, Canada have laws of this nature. Now, they are trying to make us believe that they have benchmarked. I want to invite Parliament to do its own benchmarking of this particular bill, okay, and the need for sovereignty. Because our research has actually confirmed that this bill is at total variance with those countries that they are talking about. But this bill resembles countries that government is shy to associate with. They have benchmarked on countries like Russia, Nicaragua, North Korea, Azerbaijan, Georgia, Hungary, which is now a pariah in the EU. All these countries have been isolated globally, and if Uganda continues and passes this bill in its current form, it actually risks being isolated internationally just like those other countries. The final point I want to make on this benchmarking is that if you look at all those laws, there is one common denominator amongst those countries. These are autocracies. Law is that independent civil society has been closed. In a country like Nicaragua, over 1,000 organizations were deregistered just by passing this law. In India, 20,000. Independent media has been decimated. Property of research institutions, universities has been confiscated by the state. And actually, if you look at this particular bill, it is also making such proposals.
Excuse us. If civil society, and we are saying if, we are here to open our minds and listen. If civil society is used for purposes of frustrating a government, okay? We're saying if, what should that government do? So it's not blanket that where they have banned this, maybe they were involved in bad things.
Civil society is just one of the examples that I have given.
Additionally,
but
just go straight to the proposals.
Okay. So, Honorable Chair, we have done detailed analysis, which we shall share with you as a committee. Our presentation, I think, has been shared with you. I don't know whether you have a document that looks like this. The chair doesn't have? No. It looks like this. Okay. So, Honorable Chairperson, if passed in its present form, the Protection of Sovereignty Bill 2026 will ignite a constitutional crisis and result in sweeping human rights violations across our nation. As citizens of Uganda, we prepare this petition under Article 38 of the Constitution, which empowers us to engage in civic acts to influence government, and Article 1, which declares that all power...
I'm not disrupting you, but just for the record, okay? And my colleagues, this presentation is by Protection of Coalition, Citizen Coalition on Protection of Sovereignty, right? How about forward?
It's the same.
We need, okay, so we should say forward together with, yeah, because we need to make record, right?
On behalf of.
Huh?
On behalf of.
Who is on behalf of who?
Forward is on behalf of the Citizens Coalition.
So forward on behalf of Citizen Coalition. Okay, make your presentation.
The implications of this bill extend to all Ugandans in their diversity. It strikes at the very heart of citizenship and fundamental freedoms, including the freedom of worship. Now, specifically, this bill poses a significant danger to, number one, the survival of families, national economic stability, the sovereignty of the people, the digital and innovation economy, education and knowledge, culture and arts, global labor and remittances, and national development. Our assessment establishes that more than half of this bill contains provisions that are unconstitutional, and over 70% of the bill requires total revision. In line with parliamentary rules of procedure, where such a significant proportion of a bill necessitates change, the standard practice is that the immediate withdrawal of the piece of legislation is done. On this basis, we strongly recommend that this bill be withdrawn as it fails to meet basic constitutional standards and professional legislative drafting requirements. Nonetheless, provided below is a detailed assessment of the specific risks posed by the various clauses of the bill. Now, I need to mention that we have a total of 20 issues with this bill. I will not go through them because they are already detailed here, and because of time, I'll just go to those that I think are the most significant. I think the contention around the definitions is clear, elaborated by so many actors here, and we take sides with whatever has been presented on the definition, because we believe actually that is the most contentious clause. But specifically, I'll go to the definition of disruptive activities. Under this bill, disruptive activities are defined to include any act or conduct prejudicial to or threatening the security of Uganda, any act or conduct threatening violence against any person, threatening to cause bodily harm, whether to the person to whom the threat is made or to another, threatening the destruction of property, employing, recruiting, engaging, sponsoring, or contracting any person to promote the interests of a foreigner, and then engaging or participating in a riot or unlawful assembly. Our analysis of this issue is that the clause fails to provide a clear legal standard for what constitutes an activity prejudicial to security, leaving it open to subjective interpretation and state abuse. By including threats of violence and property damage between private individuals, the bill inappropriately extends the scope of national security. These matters are already governed by the Penal Code Act, which covers assault, grievous harm, and malicious damage to property. Our recommendation is that the foreign interests need to be defined. The bill must explicitly specify which foreign interests are subject to regulation. The bill covers issues already covered by the Penal Code, such as violence and providing bodily harm, and this should be removed from this particular bill. In the alternative, there should be a standard that separates the issues under the bill from those set out in the Penal Code Act. And we also provide justification for that, which I will not read. I'll go to the second issue of contention, application of the bill. And I think that is close to where the Attorney General, we had him speak to that yesterday. According to the bill, it applies to agents of foreigners, persons engaged in political activity in the interest of foreigners, persons who solicit, collect, disperse, or dispense contributions, persons who agree, consent, assume, or purport to act as representatives of a foreigner, persons who influence the development of government policy, persons who oppose government policy. Our analysis is that the bill appears to be a redundant legislative piece of effort seeking to solve a non-existent lacuna in our laws, as existing frameworks like the Anti-Money Laundering Act, the NGO Act already regulate these areas. There are vague definitions as a tool for abuse. It could potentially create economic paralysis, and also there's criminalization of professional services. It also potentially suppresses civic participation. Our recommendation is that we need to define regulated interests. The bill must specify which foreign interests require regulation and explicitly protect those that do not. Only acts that cause actual threats to the sovereignty of the country should be suspended. The bill should set standards on a kind of acts that are a threat to sovereignty of the country. There is need to uphold diaspora rights by removing provisions that bar Ugandans from political participation based on their residence abroad, as these are likely unconstitutional. Protect capital inflow by removing restrictions on the solicitation and disbursement of funds and loans to prevent the flight of capital. Exempt professionals, explicitly exempt legal and financial professionals providing standard services to foreign clients like lawyers and accountants. The justification is clearly stated there. The Minister. No, issue 5 is the administration of the Act and functions of the department under clause 3 and 4. The bill provides that the Act will be administered by the department responsible for peace and security within the Ministry of Internal Affairs. This department is mandated to implement the Act in coordination with other government agencies. The first issue here is that we've just gone through a RAPEX process, and now we are creating more departments. Yet actually, we went through the RAPEX process to save, to increase efficiency, but also save costs. Our analysis of the issue is that standard legal drafting requires that when a law establishes a new administrative entity, it must define the rules for its constitution, leadership, and governance. This bill is conspicuously silent on the composition and oversight of the department created under clause 3. Without a clear governance structure, the department operates in a legal vacuum, lacking the accountability mechanisms necessary to prevent administrative overreach or the abuse of power. I need to mention that as members of the civil society sector, we actually faced a critical challenge when the NGO Act was being implemented. The NGO Bureau went ahead and suspended organizations on 2 occasions without the right structures for administration being put in place. In the first instance, there was no adjudication committee, yet it was clearly provided for in the law. As we speak, over 10 organizations are suspended, yet actually the NGO Bureau does not exist. The recommendation is that the bill should be amended to clearly define the composition, qualifications, and appointment process for the officers of the department to ensure transparency and accountability. I'll speak to the 7th issue, implementation of government policy, clause 8. That's on page 10 for those of you that have a copy of this presentation. This clause stipulates that government policy shall be approved by the cabinet and are implemented exclusively by government agencies and ministries. It prohibits private persons from implementing government policies without formal authorization. Our analysis is that it creates ambiguous criminal triggers. Clause 8, subclause 3, prohibits an agent of a foreigner from hindering, frustrating, or disrupting the implementation of policy. However, the bill provides no legal definitions for these terms. As these are the trigger words for criminal liability, their vagueness invites subjective interpretation and state abuse. Since agents of foreigners are citizens and some citizens are categorized as foreigners, the bill stops citizens from participating in government policy, which is against Article 38 of the Constitution on civic rights, Article 59 on the right to participate in elections, Article 1 on sovereignty of the people, and Article 2 on supremacy of the Constitution. There's also prohibition of sovereign rights. By barring private individuals from implementing or engaging with policy, the clause strips citizens of their rights under Article 1, Article 38, Article 42, and Article 72. These articles mandate that citizens participate in their governance and economic activities. Sovereignty is not merely the right to vote, it is the right to actively execute and participate in policies that affect one's life. Bureaucratic obstruction, clause 8, subclause 4, creates an unnecessary hurdle by requiring government approval for any activity related to policy implementation. This risks alienating the public and the private sector. For instance, it remains unclear if a private school owner would require special state authorization to align their curriculum with UPE or USE standards. Such red tape discourages private sector contributions to national development. The recommendation is that the requirement for formal approval should be removed. Citizens and private entities should be encouraged, not restricted, in their efforts to support and enforce national policies. The clause should be deleted. The 8th issue is prohibition of the promotion of foreign policy of another country, which is clause 10. This clause prohibits any person from soliciting, receiving, or obtaining funding or assistance from a foreigner to sponsor or organize meetings aimed at promoting the foreign policy of another country. There is inconsistency in terms of scope. There is a significant disconnect between the clause's head note and its practical scope. It is unclear if the prohibition applies only to the official foreign policies of sovereign states or any other policy originating from abroad. Since foreign policies are usually managed through diplomatic channels, prohibiting private engagement could inadvertently criminalize the promotion of bilateral or multilateral agreements to which Uganda is already a party. If the goal is to prevent importation of foreign ideas, the bill threatens national progress. Most successful reforms in Uganda are informed by international best practices and comparative research. This provision makes it legally perilous for researchers and citizens to advocate for reforms based on successful global models, effectively stifling policy innovation and the civic engagement guaranteed by the Constitution.
And we agreed that you highlight salient issues. You don't need to read word per word. We already have the document. Sure.
So issue 10 on page 13,
yes.
Clause 12, prohibition of interfering with operations of government.
Yes.
This clause prohibits meetings or the solicitation of funds for activities that undermine the general functioning of government. Our recommendation on this clause is that this provision should be removed entirely as it fundamentally prevents citizens from exercising their constitutional sovereignty and oversight roles. The detail you read.
Yeah, absolutely. Clause 12, registration of an agent of a foreigner.
Yes.
Or issue 11, yes.
Yes, I think clause 13 has been elaborated by a number of actors.
Yes.
So I'll not repeat that of issue 11. I'll go to issue 12. Registration of an agent of a foreigner.
Which is clause 14.
Which is clause 14. I think also Philip did an elaborate job
did
there.
Very well
so I'll not repeat
there.
there.
Certificate of registration, which is clause 17.
Yes.
What's that?
Okay. So let me go to issue 15, restriction on funding. I think the major issue there is that the bill offers no clear justification or empirical basis for the 400 million threshold. This arbitrary figure lacks any stated policy rationale. Furthermore, the restriction poses a severe threat to Uganda's investment climate and general commerce by targeting critical financial activities. Issue 16, which is on clause 25, reporting on foreign funding. I think Philip also elaborated that.
He did very well.
Okay.
Filing of returns.
Filing of returns.
What about this?
Yeah, filing of returns. This clause requires every agent of a foreigner to submit periodic returns to the minister detailing all funds received. The obligation to file returns is unnecessary.
Is there where you have an alternative view to what Philip presented on clause 25?
On clause 25? No, we don't.
Absolutely.
Yeah.
Okay. So, 26, which is filing of returns.
Filing returns. Yeah, the obligation to file returns is unnecessary and punitive administrative burden, particularly for ordinary citizens receiving remittances from relatives abroad or managing family affairs. This provision really duplicates existing regulatory requirements. Financial institutions and money transfer operators already submit comprehensive returns.
That's clear.
Okay. Inspection. Let me go to inspection. Okay. Issue 18, which is clause 28. This clause provides that a person appointed by the minister may, at any reasonable time, inspect the premises of an agent of a foreigner and request any information deemed necessary to give effect to the act. Obstruction of an inspector is punishable by a fine of 40 million shillings and 7 years imprisonment. The analysis is that there is absence of judicial oversight. Then number 2, invasion of private residences, because it doesn't clarify what premises are. Because, you know, considering that Ugandans are classified as foreign agents, okay? So a Ugandan grandmother who is receiving funding from their granddaughter abroad, their premises could actually be invaded, which is their home. Their privacy could be violated because of suspicion that foreign agent activity is going on there. Then it also gives the discretionary overreach and intimidation. Our recommendation is that the Anti-Money Laundering Act and tax laws already give government officials powers to conduct
and that is clear
such
too.
searches. Okay?
On issue 20, do you find, because Philip canvassed that so well too, ministers, powers to the minister, clause 30.
Yes, clause 30 covered it.
Okay.
Actually, the major issue there is the fact that it gives the minister power to revise the schedule. What that practically means is that the threshold of 400 million could actually be revised downwards to even 8 million. In that, if you're receiving, if for instance it is reduced to 5,000 currency points, it would mean that anyone that is receiving in excess of 8 million shillings per year would have to get special permission from the minister.
So you'd rather we
but
do
it
what?
could also be revised upwards. It should actually be eliminated. The minister is getting a lot of powers. The minister should not have power to revise this schedule. Because
so it should be the law.
Sorry?
On page 17.
Okay. Recommendation B. And we are saying in cases where there are restrictions, the threshold should be increased to about $5 million, and this should be only applied where there is evidence that the activities are likely to violate the sovereignty of the country.
Are you departing from that?
No, actually, we are not talking about the threshold. We are talking about the minister having power to amend the schedule.
So you'd rather the law is explicit on that?
Yes.
Okay. Okay.
No. These are two different things. They are not the same.
Okay, that's clear. Go on. Yeah. Address that. We got it. So the law should actually be the one to, instead of the minister.
Instead of the minister. Okay. The minister shouldn't have power to amend that schedule. Okay. Because as we speak, the maximum penalty for a company
is we hear you because we have done that before here. Yeah.
All right. Okay. So, Honorable Chair, I would like to end there because all the issues are highlighted, but also indicate that there's an annex which does a detailed analysis.
Yes.
Okay.
So now, because now we said for the record, because we had received a request from Forward, Forum for Women Development. So Forward is done. Thank you so much. Now, very important, because majority of you,
excuse me, Chair,
just before you come in, Patricia, are from civil society. These honorable colleagues are also products of civil society. But understand us, the question still stands. If some of the civil society organizations that draw money from other countries, if the intention of that money is to contravene the established government policy, how should we handle them? You note down, because then I have opened for, you will respond. I've opened the floor for members to intervene, to ask points for clarification or questions.
Excuse me, Chair.
Yes, Patricia, what's the issue?
I beg your pardon.
Yes.
You will notice that our memorandum did not talk at all about NGOs.
No, it is...
It is talking about the broad issues, and we were asking...
It is a movement,
yes,
women's movement, and wider civil society fraternity in Uganda.
Yes.
But we received a request from Forward.
Yes.
You see, when we are submitting on the floor, I can tell you, it's for the record. We will say we heard from. So why would you not want to be on record?
No, it's not that I don't want to be on record, Honorable. We have a colleague as part of us that would want to bring out the specific issues on NGOs. Because as we presented, the issue,
I thought NGOs are civil society.
We kind of divided our presentation.
Who is that?
NGOs.
Who is that colleague?
A part of, he's there, Yona Wanjala. NGOs are a part of the wider civil society, and that's why in my introduction I mentioned that we were representing.
Okay, no, and we are willing to hear that. So take a front seat. May we know the group that came with you? You can stand up. Stretching is healthy.
Our members from the regions, please stand up for recognition.
Okay, we will then, well, others are even in the overflow.
Yes.
Okay, then, honorable colleagues, I think it's in order that we listen, since it's the same group, we listen to them. Yes. Yeah, then we can respond accordingly.
And also, Mr. Chairman.
Yes.
Mr. Chairman, also I have the request in connection to what she has said. We have also the team.
So sit where you can access a microphone.
Yes, we have also a team, Mr. Chairman, aided by the Gulu NGO Forum. They have the views from Acholi sub-region.
But now.
Aided by Gulu NGO Forum. Maybe I'm inquiring if they can present together as the NGO Forum.
Chair.
Yes.
I will also have from a point of...
From Namayingo.
Chair,
Honorable Sibambi, your fears are taken care of.
Not my fears. I just wanted...
No,
Chair, with
I have heard.
Your permission.
Yes.
And
remember, we had, let's be fair to these people who arrived here. See, after them, we are going to entertain Bankers Association.
No,
we have.
Excuse me, Mr. Chairman. What I'm meaning is, since they are aided by NGO Forum of
Correct.
Guru, why not to allow them present
yes,
together?
But they,
this is what I'm meaning.
These ones registered earlier.
Yes.
Yes.
Chair,
the
NGOs.
Chair, I wanted to
Honorable Sibambi,
to request your chair
yes,
to guide us properly, because this is really an issue of record and also consideration of stakeholders.
Yes.
So I think they should register whether they have
Absolutely.
no umbrella body
Yes.
to know exactly who is behind a particular proposal. Or
thank you, thank you. I have said this, and thank you for clarifying it. Parliament is a house of record. Okay? It is for posterity. You are before the house. So whatever submission you are making is actually recorded. But also, you are submitting for posterity. So when I was asking, is this forward, is this what? It's in order that we record each and everything. Thank you. If it's an umbrella, give us the membership under that umbrella. Introduce yourself and tell us. And please, if your colleagues before have highlighted, you may just mention that you had it, you had this point, but it has been exhausted. Talk. Thank you. Over to you.
Thank you, Chair. One of my core is I'm known for precision.
Good. You are called Mr. Precision.
Yes.
Some clarity, Chair.
Honorable Weriche.
You know, when we started this journey, I thought it was one group of governors. But each time we are completing, another person comes. Is this going to be the last presentation so that we understand where to go next? Or there's another group going to come closer to them like that again?
So who are those?
We need to know. Because each time we complete this, something
I think I agree with you. May we know
somebody comes.
which group is that?
What is going on? I don't understand.
Thank you, Honorable.
Okay.
Chair.
Which group is that? You have a microphone. Switch on.
Thank you, Honorable Chairperson. We are from the International Country Directors Network of Uganda.
The what?
International NGOs Country Directors Forum for Uganda.
International Country Directors Forum.
Yes.
And you registered?
International NGOs.
International
yes.
NGOs.
Okay.
Yeah, and we have made the
International
submission with you.
NGOs Country Directors.
Yes.
Yeah, actually, we have you on the list. But let's listen to this. Then Bankers Association. Then Human Rights Commission. We are here, as we are here. Please, Mr. Precision, stick to your name.
You are good
Mr. Can I propose to the
Honorable Wanjala is my name.
Just a minute. Okay. Just a minute. Honorable Chairman, I want to suggest that after this presentation, we can have that group exit, such that then we can be able to deal with the others. It helps in decongesting the room.
Thank you, Mr. Chairman. Once again, Yona Wanjala is my name. I work for the Civic Advisory Hub, which is a registered indigenous Ugandan NGO working across Uganda. Mr. Chair, with me in our submission is yet another organization, Justice Access Point, presenting on behalf of the NGO sector. Mr. Chair, with your permission, allow me submit that on the 22nd of April, the Civic Advisory Hub, in collaboration with Justice Access Point, convened members of the civil society sector, totaling to 126. These were both in person and online participation, in line with the discussions and the debates of the Sovereignty Protection Bill. In the letter we received, Mr. Chair, one of the things that you requested us to highlight are the principles of the bill, how it interacts with other existing legislation, and how it also interacts with other global provisions. Mr. Chair, we provide a very key summary given the timing, and we highlight our concerns in only 6 perspectives and conclude with a recommendation. Mr. Chair, this bill seeks to establish a registration and regulatory regime for the agent of a foreigner and to restrict receipt and use of funding. Our presentation herein highlights the following: that this bill has problematic provision, and I will not overemphasize. One of it is the agent of a foreigner. The definition is dangerously expansive, capturing any person whose activities are directly or indirectly supervised, directed or controlled, or financed or subsidized by a foreigner. This is quite sweeping, Mr. Chairperson, because the majority of the Ugandan civil society receive funding from abroad. The academic and research institutions in this country receive grants from abroad. The journalists, the media organization, with any and many other agencies receive funding from abroad. This is quite dangerous because they...
Is there a country called abroad?
Okay. From foreign countries or other countries. Thanks for your guidance, Chair. Mr. Chair, with your permission, allow me proceed. That this particular bill, again, contravenes the Constitution that other colleagues have highly emphasized. Several articles on freedoms of expression, privacy, equality, and administrative fairness treatment. The bill seeks to reintroduce a prior restraint on assembly and policy advocacy. Mr. Chair, as a civil society, organizations involved in rule of law, governance, this is our business, to hold government accountable. And by doing this, we are influencing policy. So this literally means that if the bill passes as is, then close business and no critical or constructive criticism for policies will be done. Mr. Chair, again with your permission, this bill is an existential threat to civil society and civic actors. The cap of 400 million limits a lot of civil society organizations that receive funding beyond this from foreign countries to this country. It defeats the purpose of our implementation plans in line with our contribution to the national development of this country. And we believe if this passes as is, it is a threat to the existence of civil society. Allow me invite just my colleague to just highlight again 3, and we conclude.
Thank you very much. Most of the issues have been ably spoken to, and I will just harp on where I think probably we may need to, on the question of duplication of laws, which creates redundancy. We think the overarching issue for us there is duality of registration, duality of reporting, and duality of investigation, which are implied in all these laws. And that is a burden that will make the work of civil society and other actors difficult. The other issue that I want to speak to is the Uganda's obligations under the international and regional frameworks, which means that if this bill is enacted, it will also mean that to participate in public affairs, which is being hedged out, more or less. And then the
African Convention on Human and People's Rights, Article 13, the right to participate freely in government, which is again being contested here. All these are issues that we need to look at when finalizing this bill. And then if you look at the International Covenant on Economic, Social and Cultural Rights, Article 2, subsection 1, which carries an obligation to seek international assistance to implement civil and economic rights. Now, that, again, is being hedged out by this bill. Those are issues that concern us, and we would like to see that...
As we conclude, Mr. Chair.
As you conclude?
Yes. As we conclude, Mr. Chair, I just wanted to highlight one or two aspects. One on duplicity, the Uganda normative and legislative mechanism is enough to weed out any manipulations when it comes to national sovereignty. The Financial Intelligence Authority has a mechanism to see every coin that enters here. The law enforcement regime is capable of doing anything under the planet. And this alone means that this bill is going to be redundant. The other is the bill is also blind of the fact that we are in the global world. One of the clauses of the bill actually prohibits implementation of policies outside this country. If you look at the USA Patriotic Act, it has extraterritorial jurisdiction. The banks have to honor it. Uganda as a country has to honor it. So how is that going to be? And again, this bill makes some of the Ugandans stateless. If a law makes one stateless, it's evil.
How? How does it make one stateless?
If at all you are agent of a foreigner, you're a foreigner. Meaning you are stateless, you don't have where to belong. This is quite evil. It's authoritarian, and it's the legislative panic. Actually, this bill is a terror bill to this nation.
Those are you. Sometimes you want to come in and say, all these views are not views of Parliament. Yes.
Mr. Chair, you gave us a chance to submit, but just lastly.
1 second.
Yeah.
Let me try to guide you.
Yeah.
Sometimes you may have a good point, but when you go to the extreme,
you spoil it.
You spoil it. You get it? I would rather you restrict yourself to the sort of submission you made at the beginning.
You are good.
Yeah, there are very many useful submissions, points you have done, but don't go to that extent, because there is nowhere in that bill, if you've read it, which points what you are saying. Don't make...
Thank you for your guidance.
You may not like it, but please restrict yourself to the substance. Don't dramatize it.
Thank you for your guidance. Chair,
conclude, Mr. Precision.
Our recommendation is simple, as the members of the civil society sector, whose voices I represent here, Mr. Chair, that for the above reasons, we have a detailed analysis that quotes laws, precedences, and section clause by clause. For the above analysis, as elaborated in the document attached, we strongly urge this honorable committee to recommend the complete withdrawal of the Protection of Sovereignty Bill 2026. Mr. Chair, the existing legal framework is sufficient to address genuine threats to national sovereignty. Should Parliament consider further legislative actions necessary, the appropriate path is the targeted consultative and constitutionally compliant strengthening of the existing laws.
Okay.
A sweeping new statute that will suppress civil society, endangers vulnerable Ugandans, and undermines the Uganda's international standing.
Thank
we
you.
remain available to submit an additional analysis and evidence to our submission. Thank you, Chair.
Thank you. We have heard from the following organizations for the record: Center for Constitutional Governance. We have heard from these are called the Civic Advisory Hub, a group of them registered. We have heard from Forward. We have also heard from Citizen Coalition on the Protection of Sovereignty. Yes, so that's why we need the registered organizations under that, Madam Patricia.
I think
Forward.
Chairman.
I have also seen, interestingly, in the Citizens Hub, people who participated, you have more than 10 members of Forward here.
Mr. Chairman.
Yes.
I would rather we have the component organizations under that coalition.
Absolutely.
We need to know them.
Yes.
Because you see, if you ever went to the plan, you said there was a coalition, and somebody asked you, who are those? What are we going to say?
Yeah, when we are
Because even
reporting,
this
we say
coalition
we
is-
heard from.
It
So
has no legal status at
Yes.
all. People just kept, they say there is a coalition here. Let's try to work properly.
Thank you. Okay, so there is only one outstanding question, but if there's a member, at two more or one, but the question that came was, you are from the civil society. Please.
Yeah, Chair, thank you so much. I want to answer that question. The Chair asked if a civil society organization received funds to disrupt the government, what should the government do? And I just want to demonstrate briefly, how do NGOs receive money? For example, if Center for Constitutional Governance signs an agreement, a funding agreement, with an entity, let's say Open Society, I report this agreement to the bank that whose account I have mentioned that will receive money. I attach the budget and the activities and work plan to the bank. That's only when banks clear our money. If these funds were a list, the bank has an opportunity of about 2 weeks or a month before funds even come in to block that funding. Foreign remittances are cleared from the bank channels, including Bank of Uganda. We have the Financial Intelligence Authority. We have the Bureau where we file returns every
Sarah
year.
Virete.
And being a,
You
Chair, let me
cannot,
finish
you cannot
and-
say one of my activities is to overthrow government. That
No.
you can never say.
No, Chair, I want
So
I
how will
wanted to
banks know
conclude.
that this activity is what if you disguise?
Chair, I wanted to conclude that we are constantly supervised by the NGO Bureau.
Good.
The challenge we have is a non-functional NGO Bureau. And when you, because since the rationalization, the Bureau does not exist. We just have an administrator who is a commissioner. There is no Bureau, and in your amendments, you said this administrator is not a member of the Bureau. Now the ministry is busy closing NGOs with no Bureau, and you are giving it another entity to close the economic sector.
The question.
Yes.
Answer the question.
So if NGO Bureau was functional, and they detect, we have security agencies up to the village. Village intelligence, VISO, RISO, PISO.
Sarah, I can ask.
Let me conclude. When we go to the village to implement activities, we write to the DISO, we write to the GISO that we are here to do a BC, and they
that is
attend
a standard
meetings.
for all.
All NGOs.
Honorable Dole.
No, I was just asking because you had asked her.
Yes.
And I think in answering that question, because you are saying, supposing someone, a person or an NGO receives money to overthrow government. So I wanted to ask her, are you aware of anyone in this country who has been charged for attempting to overthrow government? And under what provisions of the law has government been charging such persons?
Yes, I wanted to conclude actually that we have penal code and other laws in the country. If there is anybody attempting to overthrow government, whether they are from NGO, whether they are from the church, charge them with treason.
The Honorable Odul from UPC. Thank you so much for your contribution. No, representing O2K. Thank you.
Chair, for the record, I represent Erute County South.
You represent O2K.
No, Erute.
Erute, not O2K.
County
Thank
South.
you,
But
Jonathan.
I have 3 quick questions on the general presentation.
Please, please.
And to help me when we write the report. The general principles of the bill is that a citizen here can be classified as being the agent of a foreigner if that citizen decides to oppose certain government policy. I wanted to benefit from the knowledge of Council Philip in regard to Article 26 of the Constitution, the right to property, including my land. And there is this policy of government now that if there is any colored person who comes here and say, I'm an investor and I like that land, and I'm going to produce on it, me as a citizen now, will I be restricted if I try to oppose such a thing? I know there are some projects. Would I be penalized now for trying to oppose in defense of my own land or mobilizing my community, especially for us in the north, where we are under customary land ownership? So our land belongs to Lango, the entire Acholi, Teso. So if I go mobilizing the people of Lango, the people of Acholi, the people of Teso, that there is this policy which is now coming to target our land, I can be classified with all those people that we are. I wanted to benefit the first one. The second one is this sovereignty, your interpretation of sovereignty.
Honorable Dole, in whose interest would you be doing that?
The people of Lango actually are.
So,
but is it possible?
What offense would you be committing?
Is it possible that the government can then brand me?
No.
No. I'm asking for this. I'm asking. Because, you know, this is now going to be the DPP, people seated somewhere. And, you know, people have been charged. Somebody sat somewhere and charges. I just want to benefit because when you write a report.
Second?
The second issue is, under this Article 1, your interpretation of sovereignty. And I think you quoted very well that sovereignty will be exercised in accordance with this Constitution. Is it there for your submission that any other law except the Constitution, if government wants to deal with the issue of sovereignty, they have to deal with it in the Constitution? Is it your submission, therefore, that anything to do with sovereignty should be by way of constitutional amendment, and they provide all this in the Constitution, or another law can be brought to deal with the issue of sovereignty? I hope you get what I'm asking. No. Councillor Yusuf here is saying it's already there. I have not asked him to respond. Yeah.
Okay.
Yeah.
You done?
I don't know if you're asking me to sit the other side.
No. I gave you
the third and the last one. If I am a man who is here in Uganda, and for the record, you know, for me, I'm a polygamist, and I have these several girlfriends abroad, and they would like to support me, and they keep sending me money, and it can happen to ladies also. Yes, they would like to support me with my other.
That is illegal. Go on, please. Honorable Jonathan, you have the floor.
It can happen with either gender.
Yes.
And there are these 5, 6, 7 different 15 men or women who are supporting me. So am I supposed to go to the minister and disclose? And now I also have this.
And in this case, it is not you supporting them. This is very tricky. Thank you, Jonathan. Of course, some questions are... do we have any other question, or we leave Honorable Okeyo, then I give Senior Katundu.
Thank you very much, Honorable Chair. Mine goes to Council who discuss faith-based organizations. We know that it is a government policy that all children must go to school. And it so happens that I belong to a faith where actually we believe in community or home-based education. And then it is a government policy that all children must go to school. And I receive funding telling me to go against that and have nobody going to school. We belong to there are those faiths where you will find that we oppose going to school. Supposing I receive funding in that nature, in that line, how would you term me?
As an NGO, community-based organization, you have been funded. The funder would want to promote the interest of home-based schooling. But the government policy here is that children should go to school.
Also, Chair, there are those faiths that oppose things like vaccination. They don't allow access to health, you know. So how do you deal with that?
How would you deal with that?
Relatedly, yeah.
The honorable colleagues are raising the interests of the funder vis-a-vis the recipient. Good. Please, the floor is yours, and then we...
Yeah, Council will do most of the questions, but briefly...
Oh, no. Honorable Katundu, Senior Katundu. Abdul.
Thank you, Chair. And I want the lawyers to help me. I'm grappling with this issue in my mind about the minister's power as provided for under the bill. On what basis can he grant or not grant permission? Does this bill address itself to the reasons the reason to which the minister may decline to grant
or not
that permission? Honorable Duru could have put it a little bit dramatically, but it's a very, very critical point. I just want relations between someone, they call them Munkovache, and he has a girlfriend here and is buying for her a car, like the one driven by the chair. It's around the...
You mean chair legal?
It's around 500 million shillings. I understand there are cars of those prices. Around 401 shilling, 401
One,
million
exactly.
shillings.
That etc.
Do you need to go to a minister, you the girlfriend, if the bill is passed?
Now, in this case, if there are more than one girlfriend,
you have to go to the minister and say, by the way, and then the minister, on what basis can say, by the way, you don't deserve such a car, so I will not grant you permission.
Or how did you get such a good
And the reason why I'm asking this, I'll give you my experience as a lawyer. If we policymakers are not so sure of what we're enacting, just imagine the judges. I've seen so many judgments, you know, and like, I was there enacting that law, but we never meant that. And judges are busy writing judgment. Why? Because we provided vagueness within the laws. So you just leave it to the discretion of a judge to assume what you intended. So look at the powers of the minister, and you can help us to see what we can do about it. In case we're going to proceed this bill to the merits.
Good. Thank you. Were you, just for were you here when Philip canvassed this? Okay.
It doesn't matter whether you've left. You can continue, as the chair
That's
said.
I said
You
that.
can continue sending written, arising out of our interaction.
Yes. Okay. Philip, Karugawa, and the team, and then because we have people who are waiting to...
Thank you very much, Honorable Dur. If you were to mobilize your community against a government project, you would be offending this bill. On the question of sovereignty, the Article 1 says power belongs to the people and they shall exercise their sovereignty in accordance with the Constitution. So any tampering with the way we exercise our sovereignty must start there. Let's say I have a home. It is my home, but I have delegated someone as security. I have delegated someone in charge of economy. Now, when I get home today, the person in charge, my delegate, the person in charge of security says, but boss, what time have you come? And then he begins to tell me I need his permission, which room to enter. Okay? He has inverted the power in the home. This bill is inverting the concept of sovereignty. The power belongs to the people. You are our delegates. It is not for you or for the executive to demarcate for us how we shall exercise our sovereignty. The polygamist with many girlfriends, I think that was tongue-in-cheek. But yes, you as the recipient, the girlfriend is out there. Okay, you as the recipient, you'd have to declare your source of funds. That declaration would have to be public. You'd have to register. Okay, if the car is a very big one, you have to get special permission. Then you have to submit, yes, a return to the minister. And if you default, it's 20 years. Even for failure to submit a return. Honorable Katuntu, the minister is all-powerful. Some of the clauses have got grounds, like clause 24, grounds for revocation. Clause 18, grounds for refusal. But it is so vague. He says you're no longer fit and proper. Is it about a 100-meter dash? Or, you know, what does he mean not fit and proper? In the case of financial institutions, when they say you're not fit and proper to be a director of a financial institution, it is an intellectual exercise, and they have criteria. No, this is about registration, or losing my registration as a foreign agent. If I could just touch on promoting the interests of a foreigner, which the bill punishes. In the context of a private limited liability company, those companies exist to make profit. They exist to make profit for their shareholders. Those international subsidiaries which are here making profit, they account to their shareholders. Their reporting line is profit. Okay? They are not here to make Ugandans happy. So by definition, they'll be promoting interests of foreigners. Thank you very much, honorable members. It's been a pleasure.
Chair, Mr. Chairman.
Are you saying Cafe Javas, Ugandan company, making profits outside? Okay.
Chair, I just beg. Yes. I know I'm supposed to see the other side because I have a memorandum, but I just want to tap and get
the mind of Philip
from the brains here, Philip and Dr. Beret and others. Kindly please give the interpretation of Article 8A, which was an amendment of the Constitution in respect of this bill.
Maybe, Honorable Chair.
I can for you. Or you have a Constitution?
Just briefly. Article 8A is on national interest.
Yes.
And it states that the national interest shall be, driven by the national objectives and directives of state policy.
And two?
And Parliament shall prescribe a law, which it has never done.
Yeah, and we're doing it now.
And is this national interest? Because the question that we should ask, Chair, when you go under the... no, Honorable, let me respond and finish and give counsel. Yes. When you read Article 8, the full section, the national objectives and directives of state policy already provide for civic organizations, for example, provide for foreign principles, foreign policy principles. Under Article 32, it provides for a guide for everything. This law contradicts, by the way, foreign policy principles in the national objectives and directives of state policy.
But you know,
where it comes to
national interests also override foreign interests. Am I right?
Yes. And actually, one of the questions we have in the big memorandum is, can we mention our national interests if they are beyond what is in the Constitution, or if they've changed? And if you mention a national interest out of directives of state policy, you are amending the Constitution.
Yes, but if the two clash, foreign and national interests reign supreme.
No, Honorable, if the national interests do not clash with the national objectives and directives of state policy, there is no problem.
But if the proposed national interest contravenes any provision of the Constitution, it is null and void.
No, the Constitution is national interest.
Yes. That's why we are saying when you read those objectives,
Okay.
there is a contradiction, and we have mentioned it in our details.
Yeah, we'll certainly. So
Chair.
please, and be brief.
Yes, please. And maybe
be
just-
considerate to others you entered with.
Yes, Honorable Chair, just in two questions were asked, and I'm just going to tie them together so that I respond at once. But just to...
No. Your question.
All right. So the question was around if you have religious institutions or entities which are against government programs, say, of education or of vaccination. And I will just respond in this way. The key recommendation that we make, especially in relation to creating exemption for religious institutions, it should be that the exemptions should only be applicable for legitimate religious activity.
Legitimate.
And the key word there is legitimate.
Who determines the legitimacy?
Now, again, let me just complete the submission. Legitimate in the Ugandan context, we have a plethora of laws which define, for example, what is criminal and what is not criminal. If you are against vaccination, a government program, there is sufficient laws. The Public Health Act is one of them. If, for example, you are against the education policy, there is an Education Act, there are provisions of the Constitution.
That wasn't the question. The question was, how should we handle?
That's what I'm saying. That one of the recommendations we make as from our memoranda is that other than creating more laws to address certain issues, why don't we begin with implementing the existing laws? And I just want to, again, for the benefit of the committee, Honorable Chair, reference should be made to Article 43 of the Constitution, which says that in the enjoyment of any rights and freedoms prescribed in the chapter, no person shall prejudice the fundamental or other human rights and freedoms of others for the sake of public interest. And then what the Supreme Court in Charles Onyango Bo Andrew Mwenda versus Attorney General has defined as the three-part test to the limitations of fundamental human rights. So the case we are making here, as we are drafting the law, is that Article 29, which but guarantees the freedom of worship. The freedom of worship is not an absolute right. So Article 43 creates the limitations.
That we know. That we clearly know.
Yes.
So just answer the question.
Yes.
In specific terms, and then we...
If I get him correctly,
Yeah.
he said there's nothing broken, there's nothing for fixing.
Yes.
The laws are there. Let's go and implement
That's it. So
that's exactly the case.
Thank you so much.
Thank you very much.
Honorable colleagues, it's been great. Let's allow the organizations I read to take leave and your other visitors who accompanied you. Let me clarify this. The people at the gate, the Parliament makes provision for 1,000 visitors who are given these cards. They are already exceeded. So when you, and of course there are others who visit other offices. So when you exit, then it will give a chance to others to enter. You've been very good visitors. We welcome you. If you think by this interaction there is more, please give them to us. And I'll ask who escorts you out. And Sivambi is slated to, I'll ask Engineer Alex Nyonsava to escort the visitors out. Please, you can use that exit. You've been very good people. Yes, as the rest stretch a bit, can all of us stand up? Yes. Wow. Somebody should lead us here. You can go here and lead the chorus. Yes. Yes. So the Bankers Association, please. No.